This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hey everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, reading through the Menendez brothers' 1996 retrial on trial for the homicides of their parents, Kitty and Jose. We are in the defense's case, and now we are learning all about the different types of psychological effects that this trauma that the brothers grew up with could affect them. So we have different specialists on the, or we've had Dr. Wilson so far as one of the experts on the stand talking about hypervigilance, PTSD. He has a conflict in his schedule, so he won't be back on the stand until later in the week. So we are going to continue on with some different witnesses. If you recall, we left off on Friday. No, sorry. What day did you get these? Thursday. On Thursday, part 71 of the defense's case. The cousin of the brothers, Brian Andersen Jr., testified as to what he experienced when he stayed during the summers in the house with the Menendez families. There were instances where Jose would threaten them with a belt. He knew that at the end of the day, Jose would take his belt off and keep it on the table as a reminder to the brothers, don't get out of line or you're going to get the belt. But the actual belt that he used for the beatings, this was when the brothers were younger, when they were in Muncie in New Jersey. This was before they moved to California. They had, or rather, Jose had a belt hanging in their closet that they were never to touch or move, which was the actual belt that was used to beat them when they did something that Jose didn't approve of. So we were talking about that. There was a brief little moment where he testified to some stuff outside the jury, but then the jury came back and now he is testifying in front of the jury. So we're going to finish that in 1 second. But before we get into that, I would like to thank my founding Justice Insiders, Toyota Girl 67, SLB 29488, May the Force be with you 4313, Jessica Wienand 6079, Mrs. Apples 2007, Butler 89833, Brooke JF, Jen P 773, Boom Chicka Wow Wow 1, and Kendall B 5757. Thank you all for being Justice Insiders for the Crime in Court with Heather channel. And with that, you get your name read on screen. You also get to be listed on, I'll show you, it is the Crime in Court Member Wall of Fame. You'd be listed under the Founding Justice Insiders title. If you join now as a Justice Insider between now and June 30th, you can also become a Justice Insider. All right. Let us switch over here to where we left off. So we read through the entire morning of the Menendez day, Tuesday, January 16th. Now we're going to continue with the afternoon. Like I got a piece of skin hanging off of me that is like driving me nuts because I keep feeling it. Sorry. So we are going to continue with where we left off, which is we took our afternoon break. They all went to lunch, and now we're back. So the court said, the court says, are we ready to resume? Ms. Abramson says, there's a couple of things, Your Honor, before I do. I just want to make sure the court knows where I'm going and it doesn't foreclose me. The court may recall that the defendant testified in the days before, immediately before the homicides, I believe, that Thursday night. Mrs. Menendez exhibited a characteristic rage and, in the course of it, told my in the course of it, told my client and his brother that she hated him and wished that they had never been born. Now, that's an independent event that Mr. Menendez testified to. What I want to be able to do is show how early in their lives that she manifested that behavior, the rage, coupled with that statement, and the witness has recollection of it, and the next witness has recollection of it, even years later, in I don't know what that's in whatever year this is supposed to be, or I don't know what was the court reporter trying to write there? Right here. What was she writing there? Your guess is as good as mine. Witness has recollection of it even years later in, maybe she meant to say in 1996. I don't know, because she has an apostrophe up there, but a slash and then another apostrophe and a period. Anywho, Ms. Anderson continues and says, and I'd like to be able to just show the continuum. And I can indicate to the court those are the only two witnesses that would be testifying to that, would be Mr. Anderson and Ms. Vandermolen about those two, the continuum of rage and yelling, then telling them that she hated them. Sorry, the continuum of rage and telling them that she hated them and wished that they hadn't been born, if that's agreeable with the court. The court says, without going into specific incidents that provoked this? No, no, no. Court says no or yes. Ms. Abramson says, apparently nothing provokes it. But no, I'm not going into instances that she did this, that when she did this, that one of the things she would say is that. He says, all right, I'll permit that. Thank you, Your Honor. Anything else? Says the court. Ms. Abramson says, could we finish the bicycle 402 because those are the only two things that I have left. The court says, let's have the cross-examination. Right, says Ms. Abramson. So apparently the jury must be back because now we're going to start cross of Brian Andersen Jr., cousin of the brothers. He is the son of Brian Andersen Sr., obviously, who was one of Kitty's siblings. So, and he was one of the only family members that wanted the brothers locked up for good and felt that they were guilty and basically, believed the state's narrative or whatever, for whatever reasons. They didn't want the brothers ever to get out. So they even opposed their resentencing hearings and things like that up until Brian Andersen Sr. passed away, which was, I want to say, the beginning of last year. All right. Hold on one second. Okay, Mr. Khan is going to be doing the questioning for the state, and he says, Mr. Andersen, how many days did you see the defendant ride his bike? 3. Are those 3 consecutive days? No. The court says, why don't you move the mic away? The witness says, like this. The court says, way away. Mr. Khan says, how far apart were these 3 days? 2, maybe 3. So you saw him ride one day and then 2 or 3 days later you saw him ride again, is that correct? Correct. And then you saw him ride again 2 or 3 days after that, is that correct? No, it was the first time was one day and then 2 or 3 days later the next time, and the next time it was like that, like a day and a half, because it was like into the evening hour of the day and then it came into the evening hour, so like a day and a half. And this occurred in what year? 77. And you remember that from 1977 that it was like that it was a day and a half? It was. It was a very short time, yes. And Kitty and Lyle were watching on all 3 days? Correct. And the only injury that you saw was on the first day, is that correct? Yes. And and Erik Menendez was back on the bike 2 days later, is that correct? Yes. What was his behavior like on that second day? Still in fear. How do you know that? Because it was on his face. He was telling his dad. How did you see it on his face? Ms. Abramson says perhaps he can let the witness answer. The court says, go ahead. The witness says he also told his father he didn't want to do it again because he was still in pain. Mr. Khan says, how long did that second lesson last? I'd say a few times up and down the hill because Jose got frustrated with Erik again. Well, how did that session finally end? In the same exact way the first day ended, of Jose walking the child up the street, the child then leaving his father, going to his mother, and the father throwing the bicycle physically into the garage. So he threw it in the garage physically on all 3 days? Yes, he ended every session that way. And Erik Menendez was not injured on the second day, is that correct? Yes, he was. Injured in what way? He fell down and reopened his leg again. Reopened his leg? He re-scuffed it. When he fell and your skin hits pavement, he had a scab already that was starting to form and he reopened the scab. You're saying from the first day he had a scab? First day he was injured, and then 2 days over, it started to heal, and when he was riding the bike the second day, he fell down again and had pants on, and you could see the blood coming through the pants. Well, how many different injuries to different parts of the body? Go ahead. I'm sorry, says the witness. How many different injuries to parts of his body did he receive on the first day of riding the bicycle? Elbow and his legs. So both legs, you're saying? Yes. How do you know he was injured to both legs? Because he was in shorts that night, you could see both legs were scarred up. He had scars on both legs? Well, yeah, he had scrape marks, yes. So he had scrapes on both legs. Yes. What was the injury to his elbow? It was a gash. It was just a big, like a road rash. It was a scrape. It was more than just a scrape. It was noticeable. It was big. It was noticeable. It was more than just a scrape, from what I define a scrape to be. So he probably needed stitches or some kind of medical intervention. But because Kitty and Jose are the parents that they are, and because they're the ones that could have been blamed for the injuries, perhaps, he never went to the hospital for these injuries, or very rarely went to the hospital or the doctor for any of his injuries that he sustained from the abuse. So, um, I believe it was testified to in the first trial that he still has issues and scars and things from that scrape with his arm because it never healed properly because he didn't have the medical intervention he needed at the time. His parents didn't take him. Continuing on. And on that second day, did he run away from his father so as to not get on the bicycle? Did he run away from his father? No, he did not run away from his father. So he got on the bicycle? His father put him on the bicycle. He picked him up and put him on the bicycle? Yes. Each time he picked him up and put him back on the bicycle? Yes. Every time the boy fell, he would have to pick the boy up and put him on the bike. Is that the same thing that happened on the third day? Correct. Every single time Jose Menendez picked him up and put him back on the bicycle? Correct. What was Erik doing on the third day? Not wanting to do that. How do you know that? The same facial fear was in his face and also telling his father, I don't want to ride the bike. So he was using the same words on the third day that he was using on the second day. He was repeated into making sure his father was understanding that he did not want to do this, which his father was not listening to. What was his exact words? I do not want to do this. You remember those exact words? Yes, sir, I do. How many times did he say that on the third day? The first time when he was going to do it in the morning, when they were going to take him morning or afternoon, then the third day, and then when he fell down and got back up, When he came up the back top of the hill to go back down to do it, he did not want to do it. He was crying at that point. How many times did you hear him say that on the second day? Once that I could recall. What point in time was that, when he was starting or when he was finishing? No. The beginning of that time, no, it was not. It was more like the second or third time. So after he had already fallen a couple times. And the first day, did you hear him say, I do not want to do this? After he, no, he was excited to try to learn, but then after he fell, he did not want to try it or do it anymore. The court says, okay, let's cut down on the cross on issues that really aren't relevant to the offer of evidence here. Mr. Khan says, I've completed my cross examination for the purposes of the hearing. Oh, okay, so this was not in front of the jury. I was wondering because he never said that the jury was back, but it said cross examination. This is the 402 hearing still. I wish it would have told us that. Anyways, it just said cross examination. So that was a 402 hearing with no jury. The court says, what size was the bicycle? The witness says, excuse me. The court can ask questions during a voir dire too of a witness. The court says, what size was the bicycle? The witness, the witness says, like a 20-inch. The court says, was it age appropriate? Brian Andersen Jr. says, as far as I was concerned, no. Why not? It was too big. So he not only was he forcing him to get on a bike when he didn't want to, but he was also putting him on a bike that was way too big for him. The court says, it was too big for him. Is that what you're saying? Yes. And was this a slope? The incline, yes, it was an incline. How much of an incline was that? Asked the court. The witness says, let's see, I don't know, say maybe 30, 35-degree angle. Sorry to say I don't know. It was a steep slope? To me, it was a steep slope because the cul-de-sac looked like it was down on a hole. When you were standing up where the yard was, it looked like a hole down there. Court says, okay, all right. Anything else? Mr. Khan says, no. Ms. Abramson says, Your Honor, just to be accurate, since I've been there more recently than the witness was, from the top of the yard, if you were standing on the yard, the slope might appear that deep. But in all honesty, when you're on the roadway itself, I don't believe it's as steep as 30 to 35 degrees. That's extremely steep. We have the photograph. It is definitely an incline, and if you're pushed down it, you're definitely going to gather speed. But I think the really significant part is the cul-de-sac at the bottom, at the bottom to turn so you don't run up to hit the house or the trees there. It's very difficult. It's a very tight cul-de-sac. The court says that photograph really doesn't show a slope. Ms. Abramson says, it's because we took it in such a way that you really can't see it. He says, okay. Ms. Abramson says, but the court says that was marked as an exhibit, as I recall. Ms. Abramson says, it's a real downhill. The court says, no, that photograph, for the record, has been marked as an exhibit. Ms. Abramson says, yes, 361. Court says, all right, let me hear any further argument on this. Ms. Abramson says, I think that this is demonstrated. This is not your normal bike riding teaching session, but a real willingness to inflict pain and punishment. Mr. Khan says, I would think that the evidence shows just the contrary. It was an ordinary bike riding incident. Erik Menendez, on the second occasion, this is the middle of the series of 3 incidents, tells his father just one time and one time only, I don't want to do this. This is not a situation of great terror and fear. It's just a kid falling off a bike. It doesn't have any place in this trial. The court says, all right, I've heard the evidence, the expanded offer of proof, in addition to what was offered during the direct examination of Erik Menendez, argued by counsel at that time. And the issue isn't whether this is usual or not usual. The issue goes well beyond that as to whether or not it's probative on the ultimate issues on the case or supportive of the defendant's position of terror at the time and fear at the time of the crime in the matter on August the 21st, 1989. And in listening to it, and how it's described. Although it's perhaps not the appropriate way of teaching someone how to ride a bicycle, I don't find that its probative value is great. I think its potential for prejudice and confusion of issues is substantial and substantially outweighs other probative value. Ms. Abramson says, let me indicate for the record, so the record is clear at this point for the review at some point, if we get there, that Dr. Wilson believes this is an extremely significant issue showing sadism on the part of the father and recklessness with the life of the child. And it's going to be very difficult for Dr. Wilson to be able to explain his opinions fully if he is not permitted to make reference to this incident, which he finds very significant. So I want the court to know, as an offer of proof, that Dr. Wilson does feel this is a very telling incident of the brutality with which Jose Menendez approached even the most ordinary issues of child rearing. The court says, okay, I understand your position. All right, let's then resume with the jury. So he doesn't change his mind, he just says it's not worth getting into, but it is a significant portion of Dr. Wilson's testimony. So what do you do as a lawyer? That kind of sucks. Your hands are tied. You have to try to get it in some other way, if you can. All right, so we're going to continue with cross-examination in front of the jury. The jury is back, says the court. Will resume. Ms. Abramson says, thank you. Okay. Ms. Abramson says, Mr. Andersen, you testified this morning that following sporting events, you observed that Jose Menendez would take showers with both of his sons. Do you recall that? Yes. And you also testified that there would be times when Jose Menendez would invite Erik Menendez to go back into his bedroom and then Mr. Menendez would follow and close the door? Correct. Did any of those incidents where Jose Menendez, not for discipline purposes, but by saying, let's go play or something, would take Erik and be alone with him back in the bedroom? Yes. Did those ever follow the showers? To the best of my knowledge, I don't know that answer. Okay, you don't recall telling me that they did? Objection, leading and suggestive, overruled, says the court. The witness says, when they were done with the showers, I was in the front room with Kitty while they were in the shower, and when the boys came out, they were wrapped in towels and went straight because Kitty and Jose's bedrooms was right across the hall. They would just go into their bedroom, and then Jose would go in, and then they would come out dressed. Miss Anderson says, "Okay, so you don't remember any of this following the shower incidents? Them, him being alone, the time alone with them would be drying off, and then them coming out of their room dressed." So, did those episodes when Mr. Menendez would ask to go to the bedroom to play, did those occur the day or in the evening or both? In the evening when he got home from work. So when he would come home from work, this is before dinner? No, this would be after dinner. Now I want to ask you about behavior of Mrs. Menendez that you saw on more than one occasion. Just a reminder, Brian Andersen Jr., I believe, is about 10 years older than the brothers, maybe. Like he is older than both of the brothers, but he was um maybe he's older than Erik. 10 years older than Erik. Something along those lines. So, but he is older than both Lyle and Erik. I can't remember exactly. Um, Next question. Now I want to ask you about behavior of Mrs. Menendez that you saw on or one or more occasions, okay? Did you observe her get very enraged apparently at her sons? Yes. And did you see that frequently? Yes. And did she have a particular physical posture or stance that she would get into when she was very enraged? Yes. Did you ever hear her, when she was having one of those rages, say anything to Erik and Lyle Menendez about how she felt about having been born? About their having been born? Yes. And what do you recall her saying in a rage to them about that? I wish you were never born. You're interfering with my life. I wish that you never came to live in my house as a child. It's so horrible that a mother would say that to any of their kids or even think it, let alone say it out loud. Miss Abramson asks, what do you recall her saying in a rage about them? I wish you were never born. You're interfering with my life. I wish that you never came to live in my house as my child. I wish that you never came to live in my house as a child. What mother says that to their child? It's just awful that they didn't have one parent that could love them and protect them. They had two awful parents that didn't know how to love and only knew how to abuse. Dogs are being loud and bumping into me. Hold on one second. Okay, I think they're quiet now. That just came out of nowhere. Um, yeah, can you imagine a mother saying that to a child? I can't. And it breaks my heart that they didn't have one decent parent out of the two. When was it that did you hear that during the course of both of your summer visits, 75 and 77, or only more on one, or only on one? Only on one. Which was it that you first heard this? The 1977 trip. And when she said these things, was she obviously angry? Objection leading and suggestive. Rephrase the question, says the court. What was her demeanor when she was saying this? The witness says, she at times would be upset, and at times she wouldn't be upset. It would just be something she would just say to them. Oh, so that makes it even better. So even the moments when she wasn't in a rage or angry about something, she would just say it. So she said it even when she wasn't enraged. Yes, ma'am, says the witness. Would she say it in a soft tone of voice or in a loud and hostile tone of voice? No, very stern voice. And would she say it, would you know, let's just go to the pattern of rages. Would you know what set the rages off? Objection irrelevant, calls for speculation, overruled, says the court. The witness says yes. Abramson says, would you always know what caused her to go into a rage? No. With respect to the rages, when she said, I wish you had never been born, I wish you never lived in my house, do you know what set those off? At times, yes. And when you knew that it was, when you knew what it was, oh, what was it? Things that happened, such as paint being spilled in the garage by Erik. We've heard about that already. Toys not being picked up, the house being a mess. What she expected the boys to do as far as the boys as far as chores were concerned. Even in driving down the road, just in going to the grocery store, it would just come out and it was different. It was something I wasn't used to. So sometimes you would have no idea what set her off. It was just the beat, or I'm sorry, it was just the burst that she would do. It was just the burst that she would do. Don't exactly know what that means, but okay. Ms. Abramson asks, otherwise, it would just be the kind of ordinary disobedience, was it? Or the boys' objection leading sustained. Ms. Abramson asks, was it necessarily disobedience or could it be accidents that set it off? Both. I have one other area, Your Honor, if I can find my note. Did you observe how Erik and Lyle Menendez would behave when Mr. Menendez would come home and appear to be angry or tense? Oh, they would just cower. When they sensed the tenseness of his face or even in his demeanor. Objection calls for speculation, says Mr. Khan. Sustained, the answer stricken. BS. Come on. Okay. Ms. Amerson says, let's talk about on occasions when you observed something in his face. Okay? Okay. And then you also observed Eric and Lyle to cower? Cower. Objection. Irrelevant. Evidence Code Section 352, says Mr. Khan. Ms. Abramson says, it's my last question, Your Honor. The court says, right. This was an area that we had discussed. Ms. Abramson says, no, I don't think. Objection sustained. The answer is stricken. Could we approach very briefly, Your Honor? All right. Thank you, says Ms. Abramson. So now this is outside the presence of the jury. So Ms. Abramson says, I'm not trying to elicit the hypervigilance answer, which is the one that we had discussed. This is, frankly, something the witness told me over lunch that as soon as Mr. Menendez would come home, if he looked really tense or angry, the witness described that the boys would actually cringe and cower, which is different. That's a fear reaction and not an observation on his part of Erik Menendez observing his father or scanning, because that might be too speculative. The court says, well, it also requires him to make a conclusion as far as the demeanor of Jose Menendez. And then Ms. Anderson says, if I can get into, he lived there long enough to know what Jose looked like in a good mood and a bad mood, and the boys seemed to pick up on the same things that he saw. When Jose was clearly in an angry or bad mood, he would see these kids basically doing this, as she demonstrates, like a cringing. The court says, sure, the way I do when counsel argue. What? That has nothing to do with anything, Your Honor. What is that even about? Miss Emerson says, why don't I think you're afraid of me, though, Judge? The court says, it just seems to be speculative and calls for a conclusion and opinion on his part. I don't think he's qualified to make that, to describe both the demeanor and the mood of Jose Menendez and also the reaction of the defendants to it. I think it's just too conclusionary and speculative. Ms. Abramson says, there's one other thing I'd like to bring out, which is that Mrs. Menendez consistently threatened the defendants that she was reporting all their behavior to their father and they would be punished when their father came home. The court says, okay, without going into the specifics, you want to ask that one question? Yeah, I want to tell the witness that's where I'm going, though, because it wasn't on our checklist. Well, I'll try, and if it gets too convoluted, I won't. That's rules of threats and enforcing rules of the family and what he asked before. The court says, didn't we already get into this? He said it that Ms. Abramson says he said on one occasion that when he was climbing the fence, she threatened, you'll get it when your father comes home. All right, we'll leave it then. I just hate to end with nothing. The court says it's sometimes best. Ms. Abramson says it's so untheatrical, Your Honor. The following proceedings were then resumed in front of the court. So now we're back to direct examination of Brian Andersen. And he is still on direct. So Ms. Abramson asks, Mr. Andersen, after any of these strappings that you heard, did you ever see Mrs. Menendez treating any of the injuries you observed on Erik or Lyle? No. Mr. Andersen, did you testify in the first trial? Yes. Were you also interviewed at some length by Mrs. Lansing, Mr. Lyle Menendez's previous trial counsel, and myself? Yes. To the best of your knowledge, were copies of the interviews that were conducted with you turned over to the prosecution? Objection. Calls for speculation, no personal knowledge. Sustained, says the court. Well, were you cross-examined at some length during the last trial by the prosecution? Objection irrelevant. Sustained. Do you know who Detective Zoller is? Yes. And did Detective Zoller call you about a month or so ago on the telephone? If it was even that long ago, within the last month. All right. And did he call you? Yes. Did you have a conversation with Detective Zoller? Yes. And did you learn only after the conversation was over that he had been tape recording you? It was during the conversation I asked, are we being recorded? And at that point, his recorder wasn't even on. He said, you have told to hold on. You have to hold on, sorry. He said, you have to hold on. I have to reset my recorder. He didn't even volunteer information, which I said, why didn't you volunteer the information? I thought that was very sly on his part. So he was just recording it without telling him. And based on what I know with the Illinois law, because this guy lives in Illinois, what I do know is that you're supposed to announce when being recorded. In the state of California, you told me that that is something he doesn't have to offer and or do. So is that a yes? Yes. Okay, and did Detective Zoller approach you today seeking to talk to you some more? Yes, he did. And what did he say to him, or what did you say to him when he sought to talk to you? I would not talk to him because I do not trust him. So you don't trust Detective Zoller. Awesome. The lead detective in this case. The cousin doesn't trust him. Was your lack of trust based on this tape recording? Yes, ma'am. Thank you, says Ms. Abramson. Mr. Gessler says, I have a few questions also. So now this is direct by Lyle's defense team. So that was direct by Erik. So now we're going to have Mr. Gessler ask some questions for Lyle. Mr. Andersen, during your 1977 visit when Lyle Menendez was approximately 8 and 9 years of age, was there any incident that stands out in your mind in which he was punished with the belt? Yes. Could you tell us what that incident was, please? When I cut the flower heads off. Well, tell us about that. I had to pause because the dog was eating the plant. So sorry, the puppy is being rambunctious this afternoon as I'm recording. So he says when I cut the heads off of the flowers, she says, tell us about that. And Mr. Khan says, objection, irrelevant, evidence code section 352. The court says, sustained, we've gone into the specifics of incidents and the court has already ruled on that. Mr. Gessler says, was there any incident in which you did something wrong and Lyle was punished with the belt as a result? The flower incident. And did you tell Mrs. Menendez that you were responsible for cutting the flowers? Yes. And were you punished with the belt for it? No. How old were you at the time? I would be, 16? So he was maybe like 7 years older than Lyle and about 10 years older than Erik. Did you hear Lyle punished with the belt for that incident? Yes. Was there anything you observed about Lyle the next day as to how he was walking or carrying himself? He was so stiff and so sore that he did not even play tennis that morning. We had to wait the afternoon so that he could walk it off, as opposed to his father having him walk off the soreness that he had presented to him the night before. What? Did you try to tell Mr. Menendez that you were responsible for cutting the flowers and that Lyle was not? He did not want to hear about it because of what Kitty had told him. What I had to say was irrelevant. Is that what he told you? Yes. Were there ever any times that Lyle Menendez asked you to intervene on his behalf because of these whippings he was receiving? Yes. Objection, irrelevant, evidence code 352, sustained, says the court. Mr. Gessler asks, did Lyle ever express to you fear of being hit with the belt? Yes. Objection, irrelevant, court says overruled. When was that? Says Mr. Gessler. May 77 trip. How many times did he express fear to you of being hit with the belt? 4. Those were separate occasions? Yes. Did you, after that, ever try to intervene with Mr. Menendez on his behalf? No, I refused. Why? Because of the fear I had of Jose myself. I did not want to feel the ramifications of him on me for what I seen him doing to his boys. Mr. Gessler says, thank you very much, sir. The court says, all right, cross-examination. Ms. Abramson says, Your Honor, may we approach before cross-examination briefly? The court says, sure. Ms. Abramson says, thank you. And now we have another little, I'm going to call it a sidebar for now. It's arguments outside the presence of the jury. But they didn't send the jury out, so I'm assuming it's just a sidebar, like they came up to the front of the room. Ms. Abramson says, because of some other issues and the way they arose in this case, I asked to approach because Mr. Khan has a tendency not to ask the court's permission to do things that usually are asked. Specifically, we had asked Detective Zoller for the tape recording that he made of his interview with this witness, and Detective Zoller said he'd be happy to turn it over to us, and then he told us that Ms. Nahara forbade him from doing that. So, if Mr. Khan is planning on using anything from that tape, excuse me. Oh, I had a cough. Sorry. Paused it so you guys didn't have to hear me. The court says, do you intend to use that? Ms. Abramson says, we would like to see it. Court asks, or the contents of it? No, says Mr. Khan. Ms. Abramson says, the same way with any sort of impeachment, I know that Mr. Anderson's father, as the court knows, is a prosecution witness, and I don't know if there's any information I remember his interview where he ascribed certain motives to his sons, this witness, for testifying, and I just want to know if there's anything like that that Mr. Khan was planning on going into to try to. Ms. Towery says, can I interject as well? My understanding of the tape recording incident was that Detective Zoller thought that he was recording it, and it turned out that his recorder wasn't working, and he turned it on. And that's when he disclosed to Alan Andersen that he had believed that he was recording the conversation. And Mr. Khan says that he's not going to use the recording. There may not be much of a recording as a result of the malfunction or whatever happened, but there may be a report or there may be information that Mr. Khan might be seeking to use. And if so, we would ask for discovery of that as well. The court says, well, why would you be entitled to it before he asked the witness? Ms. Towery says, same reason we would be entitled to the recording. If we're entitled to the recording, we're entitled to the content. The court says, why would you be entitled to the recording until he cross-examines? Ms. Towery says, go ahead. Ms. Abramson answers and says, just to make sure there isn't any 1101 type violation with some district attorneys, and certainly with the previous ones in this case, they tended to ask leave of court for things that could be controversial. Mr. Khan doesn't do that. He does it in front of the jury. The court says, well, that's not, at this point, I'm not going to interfere with either side's right to cross-examine the witness. If either side has information that they want to use, we just have to deal with it on an objection basis. The rules of discovery permit them to impeach witnesses, and I don't want to interfere with that. I'd do the same with you. I just don't think I don't think it would be fair. Ms. Towery says, I understand it has been our position consistently, Your Honor, throughout both trials, I think that we are entitled to the prosecution's impeachment evidence under Brady type analysis, and I think briefs have been filed on that. I don't know that the courts ever specifically ruled on it. My other possibility would be that there may be discoverable information in the content of the conversation, such as the statement of the defendant. For example, if Mr. Andersen relayed something that Lyle Menendez or Erik Menendez might have said to Detective Zoller, I think clearly under Proposition 115, we'd be entitled to that. So we just don't know what it is at this point. The court says yes, but then it would just go back to the old discovery rules of turn to the people and say, give us everything. The obligation is on the prosecution to comply with the discovery orders and the common law rules of discovery, the constitutional rules of discovery, and the court assumes that they are doing that. I don't think it's appropriate now to go in and have them turn everything over to the defense so that you can verify that that's what they're doing. So anyways, that's my ruling. Mr. Gessler says, we would state, however, Your Honor, that we have received no discovery from the people as to any statements made by Lyle Menendez or Erik Menendez to this witness that might have been repeated since the last trial. The court says, okay, then we shall assume there are none. Now we're back in front of the jury. Cross-examination continues, or begins rather. So Mr. Khan asks, Mr. Anderson, you were told by Detective Zoller that the prosecution would have liked to have an opportunity to speak with you before you testified. Is that correct? Yes. And you told Detective Zoller that you were not going to allow the prosecution an opportunity to speak with you. Is that correct? It was my decision, correct? Can you tell us why you decided that you didn't want to speak with the prosecutors in this case? I didn't feel I had anything to offer that would benefit either side of the situation. And you decided that you were the best judge of that, is that correct? On my own terms, yes. Because you're aware of all the evidence that has been presented in this trial in the last, and you know what's important and what is not important, is that correct? Objection. Argumentative, says Ms. Abramson, and the court says rephrase the question. Yeah, you better rephrase that. Mr. Khan says, are you aware of all the evidence that has been presented in this trial and in the last trial? I'm aware of the evidence from the last trial and up to certain days of this trial, yes. You you're familiar with all of the evidence from the or from the first trial? Not 100% of all of it, most of it. Are you familiar with all of the legal issues in this case? I'm not a legal expert. No, sir, I'm not. Are you familiar with all the expert testimony in this case? No, sir. Then how can you say that you are in a better position to determine what is relevant and what is not relevant in these proceedings? Objection, argumentative. Rephrase the question, says the court. Mr. Khan says, are you saying that you feel that you are in a better position than the prosecution to determine what is relevant and what is not relevant in these proceedings? I'm going to object to that also, argumentative and irrelevant. The court says, overruled. The witness says, I feel as a 35-year-old man, I have the right to decide who I want to talk to and who I don't want to talk to. Of course you do, and I'm asking you why. It's a decision that I have made. I have no answer why. I just made that decision. You have no answer, is that correct? Correct. Would you say that you're biased in this case, Mr. Anderson? No, sir. Then why are you unwilling to speak to the prosecution if you are not biased, sir? Asked and answered, says Ms. Abramson. Overruled. And argumentative as asked. Overruled, says the court. Ms. Abramson says, just wait, there's an objection. The court says, the objection's overruled. Ms. Abramson says, sorry, I couldn't hear you. The witness says, because of the way Mr. Zoller presented himself to me on the phone from the way the situation was. And you are holding that against the prosecution, is that correct? Because Mr. Zoller presented himself on the phone because he lied and was recording the conversation. He says, I felt that if you have a team member that is presenting himself as such, I made myself decide that it was one team member's the same and they're probably all the same. What is it that Detective Zoller did that offended you so? Number one, he lied to me. Lied about what? As far as being recorded, then all of a sudden the recorder is all of a sudden not on and he has to re-put it on because he says he forgot to put it on. Why would he not announce that I'm being recorded? Isn't it true, sir, that you do not want to give the prosecution anything which may be used against Erik and Lyle? I would have nothing different to say to you than I have to the defense. But you would not give us the opportunity to ascertain that. Is that correct, sir? I have a life also, sir. No, I do not have time to do that. You do not have the time. Is that what you said? At that time I did not have the time. At what time? At the time when Mr. Zoller wanted to talk to me on the phone. I'm talking about this morning. You were told this morning that we wanted to speak to you. Is that correct? Yes, Dr. Zoller did come up and well, did you have time to speak with us this morning? Let him answer, says Mrs. Abramson. The court says, address your remarks to the court. Abramson says, I'm objecting that he's not allowing him to answer before he jumps on him. Sustained. Finish your answer if you did not. The witness says, at the time this morning, I had nothing different than I would have offered to you that I offered to the defense. Mr. Khan says, you didn't want us to have the opportunity to question and find out if perhaps we wanted to know information from you that maybe the defense doesn't want to hear about. Objection, Your Honor, argumentative. Sustained. Mr. Khan asks, did you think that perhaps the prosecution might want to know certain things that maybe the defense doesn't want to hear about? Objection, argumentative, and I would object to counsel using that terminology again. Court says overruled. The witness says, rephrase the question, please, or ask the question again. Mr. Khan says, do you have a learning disability, sir? Yes, sir, I do. What type of learning disability is that? Dyslexia. Does that impede your ability to recall details? Short-term memory. What do you mean by short-term memory? Such as reading a book and not realizing the paragraph that you read before. Does it affect your long-term memory? At present, no. In the past, has it? It's taken events this far. In the event I might have forgotten, but no, it has not. Have you ever taken notes to help you recall things? My documentation I am working on, I am not a very good documentationer because of the way I write. I think he made up a word there, but we'll go with it because I like it. Documentationer. My question is, have you ever taken notes in the past to help you recall things that happened long ago? No, sir. How would you describe your long-term memory? Fairly good. How long have you had this condition of dyslexia? Birth. The question I asked you, sir, is whether you felt that perhaps or did you recognize the possibility that perhaps the prosecution would want to ask you about things that the defense would not? No, I did not. That ever occurred to you that perhaps the prosecution who is seeking to convict the defendants might have a question or two of you that the defense does not? No, sir. And you didn't want to give the prosecution a chance to ask those questions. Is that correct, sir? Objection, argumentative, says Abramson. Overruled, says the court. The witness says, my thought is that she would ask the same questions that I've already been asked by the defense. I thought you'd be reading from my testimony before and asking me the same questions, so I found it irrelevant. Mr. Khan says, if that were the case, sir, Ms. Abramson says, Your Honor, I'd object. The court says, had you finished your answer, sir? The witness says, you could say yes, I have. Mr. Khan says, if that were the case, sir, then did you even speak to us and tell us that is the reason why you refused to talk to us? Objection, argumentative. Rephrase the question, says the court. Mr. Khan says, did you tell us that the reason you did not want to speak to us is because you're assuming that we're going to ask questions concerning matters for which we already know the answers? You didn't ask the question. You didn't ask that question? Didn't ask that question, I assumed. And did you question in your own mind why would the prosecution want to ask you a question for which we already know the answer? Ms. Abramson says objection argumentative. Court says sustained. Objection sustained. It's argumentative. Ms. Abramson says, thank you, Your Honor. Mr. Khan says, are you willing to speak to the prosecution now outside the court? Ms. Abramson says, objection, Your Honor. Irrelevant since he's on the stand. Overruled. The witness says, ask me your questions. I have nothing to hide from you. Mr. Khan says, now, did you receive a large sum of money from Lyle Menendez some time ago? Yes. When was that? About 9, just before the boys, my brother was being married. I believe it was 1990 in February. And how much money did you receive from Lyle Menendez? $8,500? What was the purpose of that money? To pay off a medical bill. I had my appendix removed and I did not have health insurance. Is that a loan or a gift? In the beginning, it was a loan. As of present, we have not discussed the final outcome of the loan, so I don't know. I don't have an answer for you whether it's a gift or a loan. Did you tell Detective Zoller when he called you on the phone that that was a gift? Objection, Your Honor. Overruled. The witness says, in the beginning, it was given to me as a gift, but then in a conversation afterwards, it was asked if I would have a way of making up a payment schedule to pay him back. And at that point, he says whatever could be, and then set forth he was arrested before we had a chance to, of course, come up with an arraignment, an agreement. Mr. Khan says, and as you now stand, you may have to pay the money back to him at some point. Correct. It's undermined for myself because we have not yet discussed it. So I don't have the answer for you. If Lyle Menendez likes, he can tell you to forget about that $8,500. Is that correct? If that's his decision. So he could just say, you're too much of a hassle of a friend, so don't worry about the money. Or he could say, you're such a good friend, I don't need the money back. Either way. The witness says, I have no idea. I'm not Lyle. I can't answer that question. I don't know what his decision is going to be with that money. We have not discussed it. I don't have an answer for you. Mr. Khan says, would you like to please him? I like to please anybody. You didn't please the prosecution this morning, did you? Ms. Abramson says, objection, argumentative, sustained. So now, not pleasing or being a person who wants to please people and skipping out on having a recorded conversation with someone who is on the side of liars and the people who want to put away my cousins. Do you think that I'm really going to want to do that? Uh, Doubtful. Seriously, doubtful. Mr. Khan says, when do you think that if you testified well on his behalf, it might please Lyle Menendez? He says, I don't know. I don't know what to say about that. I'm just telling the truth, what I know the truth is, how he perceives it in his own decision. Do you know when a final decision is going to be made as to when and how to pay that money back to Lyle? No, sir. We have not had a conversation about that money since before his arrest. So I don't have that answer for you. If he came to me to offer a payback to pay it back, I would. Do you feel that your testimony here might be helpful in his defense? Objection, Your Honor, irrelevant. Overruled. The witness says, again, I don't decide for Lyle. That is something he did for me. If his decision is to pay him back, I pay him back. I don't know. You have to ask Lyle that question. Khan says, now you went to lie. Oh, sorry. Now you went to live in the Menendez residence several different names or several different times throughout your life. Is that correct? Correct. And the first time was before Erik Menendez was born? Yes. And that was in 1970? Yes. How long did you stay? 1 month. The second time you went was 75. And how long did you stay? The entire summer vacation, probably. Wait, uh, what, a 3 month, 4 month period? Well, when was the next time that you went? 77. How long did you stay? The entire summer vacation. Once again, a 3 to 4 month period, correct? Correct. After that, did you spend any time in the Menendez residence? No, sir. You spent a total of somewhere between 7 to 9 months in the Menendez residence. Is that correct? That sounds correct. Now, you said that there was a change in his behavior from the time that Erik was 4 to the time that he was 6. Is that correct? Correct. I'm going to object to that, says Ms. Abramson, misstates the testimony. The court says, all right, perhaps the ages are a little different. Ms. Abramson says, yes. The court says, why don't you correct that? Mr. Khan says there was a change from his behavior between ages something. Between what ages? Between what ages? The years 75 to 77. Did you notice any change in his behavior from the time that he was 2 years old? Objection, Your Honor. Vague. Overruled. As he was a baby from the time now, are you talking back from when he was 2 years old to 75, or are you talking about 2 years old to 77? I'm talking about from 2 years. Did you see him when he was 2 years old? In Hinsdale. Whenever he lived at wherever he lived at the time, did you see him when he was 2 years old? Yeah, I saw him as a baby, yes. Did you notice any change from the time he was a baby to the time he was 4 years old? No. Do you recall describing him as a baby as being uppity? Do you recall describing him as a baby and being uppity? I don't know. The word up is the word that I should have used. I say he's not a snob at that age. Huh? Okay. Up is the word that I should have used. I'd say he was not a snob at that age. But you did previously testify that a baby he was uppity. As a baby he was uppity. Your Honor, I'm going to object, says Miss Abramson. That was also clarified at the last trial. It's misleading. The court says, Counsel, let's not discuss what might or might not have happened in other proceedings. Your objection is what? What is your what is your objection? Why does he repeat himself? Ms. Abramson says improper impeachment overruled. The witness says, in the form of dyslexia, I do have a tendency to use words that I don't even have the meaning, and I try to use those words in a sentence. That is a form that I have with my dyslexia. It is a fault of mine. I use words that I should not use because I think I know the meaning. If I use the word uppity, I apologize. I should have used up. Mr. Khan says, I'm not asking you to apologize. I'm asking what word was used. In the first trial, did you describe the defendant at the age of 2 of being uppity? I don't recall. If you have something, can I read it? I'll be happy to read it. Now, can you tell us why you began visiting the Menendez family in 1970? I enjoyed I enjoyed Lyle and I also enjoyed Kitty. Where were you living at that time in 1970? Oak Lawn, I believe. So, Illinois. And where were the defendants living in 1970? That will be the house before the Munzie house. Which house was that? I forgot the name of the house. What city was it in? New Jersey. What city? I believe the ownership was in New Jersey. What part of New Jersey? I don't know. Whatever. I don't know. I've never looked at a map or anything of that area. I just went where I was going. How far away was it from where you were living at the time that you invested in, or that you visited in 1970? Say that again. How far away from your own house was the Menendez residence at the time that you visited them in 1970? I Ms. Abramson says, Your Honor, I'm going to object as beyond the scope of direct given the limitations. The court says, Well, he's just asking for a time frame. And did you go into various places where he lived and visited? So overruled. The witness says, "You had to get on a plane. I had to be on a plane. So if that answers your question, I had to get on a plane and went fast, went towards New York, New Jersey. And then you went back again in 1975? Correct. And where were you living at that time? Illinois. What part? Oak Lawn. And where were they living in 75? In Muncie. And did you go back in 1975? In 75, because I wanted to be with my cousins. Because did you enjoy your stay in the Menendez residence the first time that you went there? For the time I spent the 1 month there, yes. And during any of these times that you stayed there, were there other relatives that stayed there? No. And then, excuse me, Doug yawned and made me yawn. And then after 1975, you went back. Not lick my face, thank you. Uh, he went. He then went after 1975. You went back and visited in 77. Correct. After spending 3 or 4 months in 75. Correct. And how much time? And you spent another 3 or 4 months in 77? Correct. So you were 13 years old when you went in 75. 13, 14. And then you were 15 or 16 at the time that you went in 77? Yes. Can you tell us why you decided to go back? Excuse me. Why you decided to go back in again in 77? I was told by my father I was going. So your father made you go back? Yes. And that's Brian Andersen who testified in this trial? Yes. Are you saying that you went back in 77 against your will? Yes. You asked me to show you the place in your testimony. Let me direct you to page 11486, directing you to lines 18 and 14 to 18. Ms. Abramson says, just a moment, counsel. The court, Mr. Khan says, line 20. The court says, just read it to yourself. The witness says 14 to 20. Yes, says Mr. Khan. The court says, just read it to yourself. Ms. Abramson says, what lines are you asking him to read? 14 to 20. I would object, Your Honor, and ask to have the witness read all the way down to 23. Court says, all right, read through 23. The witness, I'm sorry, Mr. Khan says, okay, so do you recall when you were asked about the deposition of Erik Menendez as an infant, you described him as being uppity? Ms. Aberson says, Your Honor, I'm going to object and ask that the whole passage be read. The court says, one question at a time. We'll get it all out. You can answer the question. The witness says, it is written, yes, the word uppity is used. When you say it is used, you're saying that it was your word, is that correct? Yes, that's my words. Court says, did you clarify that at some point in the passage just read there? The witness says, what, just now when I read it? The court says, yes. Was it clarified in there? Yes, it's my answer, was uppity, says the witness. Ms. Aberson says, Your Honor, to answer the question, to answer the question, to answer the court's question, it's clarified. Court says, I'm asking the witness. He's on the stand. You're not on the witness stand. Ms. Abramson says he can't read. Court says, did you use any other word besides uppity? Happy on line 23, says the witness. Okay. Mr. Khan says, now, your father told you that you had to go back in 1977? Correct. Were you happy to go back? I was very reluctant. No, I was not. Do you know why your father told you to go back? Objection calls for speculation. Sustained, says the court. Ms. Abramson says, or hearsay. Sustained. Thank you, Your Honor. Mr. Khan says, why do you feel you had to go back? Ms. Abramson says, again, Your Honor, I would object that it's irrelevant. The court says, overruled. The witness says, truthfully, I don't know why my father sent me there. The only thing I can speculate is because the court says, don't speculate. Sorry, I can't stop yawning now that like my dog got me started and it's not stopping. Sorry. The witness says, "All right, I don't know. He never discussed it with me. He just told me that I was going and that was final. Were you having problems at home?" "Objection, Your Honor," says Ms. Abramson. "Sustained," says the witness. Mr. Khan says, "Your father didn't give you a choice?" "No, sir." "And you didn't ask him. Is that what you're saying?" "He did not offer the answer when given. It was final." "He was a very dominating type of person?" "Yes." "Your Honor, I think we're getting a little far afield into his field." The court says, "All right. I assume that's the last question in that area." Mr. Khan says, "Yes, Your Honor." "Now, by the time you went back to visit the defendants in 1977, did you notice a change in his behavior?" "I don't know who his is." "That is Erik Menendez." "Yes." "Do you recall that at the time he was more angry and destructive?" "Yes." "As a 6-year-old, you would describe him as vindictive, angry, and destructive?" "Objection, Your Honor." "Overruled," says the court. The witness says, with inanimate objects, yes." Mr. Khan says, "And he was vindictive in what sense?" "He would just take his anger out on his toys or whatever he was playing with. It could be a log, whatever, in the yard, a tree, it could be anything." "Now, you saw Erik Menendez get struck with a belt, is that correct?" "Correct." "And you said that you saw bruises on his body?" "Correct." "And of 7 to 9 months that you spent with the family, how many times did you see bruises on his body?" "Most cases, after the belt was used. I don't, in fact, like I told the defense, I just don't have a number of how many times the boys were beaten with a belt or whipped with a belt. Excuse me, whipped with a belt." "Did you previously testify that you were aware of them being beat with a belt between 12 to 15 times?" "I may have thrown a number in the air. I just don't have a pinpoint time of how many times they were hit with the belt." Well, what I'm asking you is about the number that you decided to throw in the air under the oath the last time, Mr. Anderson. He says, "I probably." Ms. Abramson says, "Objection." The court says, "Objection sustained as to the form of the question." Ms. Abramson says, "Thank you, Your Honor." Mr. Khan asks, "Did you testify previously that you saw?" Mrs. Abramson says, "We'd asked for a citation before it's read, Your Honor." The court says, "What page are you referring to?" Mr. Khan says, "I'm looking for the page now, Your Honor." What is your best recollection as to the number of times that you were aware of the defendants being struck with a belt as of the last time you testified?" Ms. Abramson says, "Object to the compound form of the question." "Overruled," says the court. The witness says, "The best number that I have for that." Mr. Khan says, "Right. The last time that you testified, what is your recollection concerning the number that you estimated that to be?" "Objection, Your Honor. It calls for hearsay." The court says, "You're asking for what he said in the former trial?" "Yes, Your Honor." Overruled. "Do you understand the question the last time you testified in the former trial? How many times did you?" The witness says, "If it's written 15, I probably did say 15." Samerson says, "Well, I'm going to object and move to strike. The witness is speculating." The court says the answer is non-responsive. The objection is sustained. Mr. Khan says, "I'm asking you, do you have any recollection today of the number of times that you estimated the defendants were struck with a belt and you saw bruises?" Ms. Abramson says, I'm going to object to the form of the question as compound. Sustained. says the court. Mr. Khan asks, do you have any recollection of the number of times that you were aware that the defendants were struck with a belt? He says, I'd have to say sometimes 2, 3 times a week. Wow. So now we're getting to frequency. 2 to 3 times a week. That's a lot. I'm asking you about your testimony the last time, Mr. Anderson. I'm going to object, says Miss Abramson. That's a different question than bruises. The court says, okay, counsel. His question had to do with the number of times being beaten. It's unclear as to whether you're asking testimony in the trial or in this trial or in the previous trial, so why don't you clarify, Mr. Khan? Mr. Khan says, okay, in the prior trial, did you give an estimate of the number of times that the defendants were disciplined with a belt? I probably did, yes. Do you recall that estimate being 12 to 15 times? Ms. Amerson says, misstates the testimony, Your Honor. Call the court's attention to the page with lines 6 through 9. Court says, is that what you're referring to, Mr. Khan? Mr. Khan says, I'm referring to what starts on the previous page when he talks about being struck with a belt. Ms. Amerson says, he talks about seeing bruises. Court says, why don't you read it and then ask the question as to whether it is his testimony? Mr. Khan says, do you recall giving the following questions and answers? Ms. Abramson says, I'm going to object to this. The previous question I objected to because it's not supported by the transcript. Court says, right. Now we're going to have the question read back from the transcript as to what he said before. Ms. Emerson says, I need counsel to cite, Your Honor, where he's going to read. Starting at page whatever. And then Ms. Emerson says, what line? He says 14. Do you recall being asked the following questions and giving the following answers? Question, were the boys ever disciplined with a belt? Answer, yes. And can you tell me how you know that? Answer, because at that time, we were disciplined at the same times together or separate instances, and I was either told on separate instances to stay in the front room and watch the TV. Kitty at that time would turn up the TV, or at times when I was in the same room where our rooms were side by side, you could hear he indicates sounds. You could hear the belt, because I also received it when I was a child. Question, and would you see bruises? Answer, yes. Question, on the boys after that? Answer, yes. And they're above their thigh area for about where the belt would hit. Question, upper thigh? Answer, upper thigh, lower buttocks area. Question, is this something that happened once or more than once? Answer, I would have to say 12 to 15 times. Do you recall giving those answers? Yes. Okay. And your estimate at the time was that they were struck about 12 to 15 times. Is that correct? Samuelson says, objection misstates what was just read. Court says overruled. He's asking the witness's characterization of his testimony. The witness says at that time, yes, that's the answer that I would presume was the number that I had in my yes. Mr. Khan says, now you're saying that in the 9-month period that you stayed with the defendants at their home, they were struck once a week. Is that correct? Objection misstates, Your Honor. Sustained, says the court. Mr. Khan says, how often is your estimate today as to how often they were struck? The boys were struck at least once a week, he says. So at least weekly. All right. But if they were struck once a week, Mr. Anderson, and you stayed there for 9 months, would it? I'm going to object to that, says Ms. Abramson. He never said he stayed there 9 months. Court says, counsel, you're really arguing here. Ms. Abramson says, misstates the testimony. Objection sustained. Let's keep it to a legal objection. Ms. Abramson says, I'm sorry. Mr. Khan says, your estimate here is you may have stayed with the defendants as long as 9 months. Is that correct? Objection misstates the testimony. Overruled. Witness says, in the times of the years I was there, it was a total of about 9 months. Mr. Khan says, and if they were struck one time per week, it comes out to a lot more than 12 or 15 times the entire 3 times that you visited. Isn't that correct? My math is not correct in my own mind, so the number that I put on there and the math doesn't. It doesn't. That's the number I gave. Were you doing quick math the last time you testified? My math is not the greatest. You could say I was doing quick math. I just don't. I don't add, subtract, divide, or multiply very well. Okay, but do you? You gave your best estimate at the last trial, didn't you? Objection, argumentative, overruled. The witness says, I was trying to give the best estimate I could possibly come up with, yes. Mr. Khan says, and your best estimate was 12 or 15 times? Correct. Now, were you ever struck by a belt by Jose Menendez? No. And yet you did things that were malicious, is that correct? The word mischievous would be used, but yes, I did say malicious. So this was your word in the first trial, malicious, is that correct? Yes. You said that you did things that were malicious, is that correct? Correct. And one of the things that you did was you cut off all the heads of Kitty Menendez's flowers, is that correct? Yes. Now, when you gave a statement to the defense, do you recall giving a statement to them on April the 26th of 1992? Was that in Oak Lawn? I'm asking if you recall giving a statement to the defense attorneys in 92. Yes, I remember talking with them. What was that in Oak Lawn? Correct. Did you specify at that time that you were the only ones? You were the only one who cut the flowers off the plants? To the best of my recollection, I've always known I was the only one that cut them off. Well, I'm asking what you told the defense investigator or defense attorneys at that time. Yes, well, did you say that we cut the flower heads off the plants? Your Honor, I'd object at this time. Counsel has no way of proving this up. Court says overruled. The witness says, was the word we used in the sentence? I may have used the word we because we were all together, but I'm the one that performed the work. They stood and watched. Mr. Khan says, did you say that in the beginning, Kitty never got upset about things like that? She was totally passive? In the beginning, she that's how she worked with me, and also usually in general. But it built as the time went on. She would come to approach the situation calmly, and then she would just turn and just change as the time went on. She approached it calmly. Then it eventually sunk in, and the anger came out. Uh-huh. And either Kitty nor Jose either struck you or hit you with the belt in any way. Is that correct? No. In fact, you even once threw a rock at Lyle Menendez and caused some serious injury to his face. Is that correct? Yes. In fact, you even started a rock fight with him, is that correct? Yes. This was in 1997. I mean, sorry, 1977. Yes. And you were 15 years old at that time? 15, 16. And he was 9 years old? Yes. And you started a rock fight with a 9-year-old boy? Yes. Were you trying to hurt him? We were both trying to hurt each other. It was the 15-year-old. It was the 16-year-old that started the fight, is that correct? Yes. And the injury was so severe that his parents were concerned that he would not be able to see correctly, is that correct? Yes. As a result of injuring Lyle Menendez to the extent Jose threatened to send you home, is that correct? Yes. Did you feel that that was remarkable restraint given the injury that you had just inflicted upon his 9-year-old son? Objection calls for speculation. Court says sustained. And conclusion, says Ms. Abramson. The court says sustained. Mr. Khan says, did he actually go so far, Mr. Anderson, as to send you home? He made the phone call. My father talked him out of it. Mr. Khan says, objection. I would object to that as non-responsive. Ms. Abramson says, well, counsel, the court says the fact he made a phone call is responsive. The objections overrule to that portion of the answer as far as what his father did is strictly hearsay. It's stricken as hearsay. Mr. Khan says, I'm questioning you solely in regard to what Jose Menendez did in response to you hitting his 9-year-old son with a rock and causing a serious injury. Did Jose Menendez go so far as to send you home? No. So what was your punishment, Mr. Anderson, for the injury that you committed to the face of Lyle Menendez with a rock? I was confined to my room and had to use the window to urinate. I was not allowed out of the room. Even when I knocked and said I had to go to the bathroom, I was not let out of the room. I had to use the window to urinate. You had to stay in your room. Was that the punishment? Yes. And then you were told after that that you were no longer invited back to the home of the Menendezes. Is that correct? When I was leaving in the end of that summer. Uh-huh. And in fact, you were disappointed that Jose Menendez was not going to let you come back to his home anymore. Is that correct? I was disappointed not being able to see my cousins anymore, correct, in their environment. And you told Kitty Menendez that you were upset that you were not going to be able to come back after 77. Is that correct? I don't recall. Well, do you recall telling the defense investigators in Oak Lawn on April the 20th of 1992 that you told Kitty Menendez that you were upset about not being able to come back? I'm thinking of my mom right now. I remember discussing it with my mom. I may have discussed it with Kitty. I was adamantly upset to the fact that I wouldn't be able to see the cousins again. Did you realize that because that had something to do with you hitting Lyle Menendez in the face with a rock? As one scenario, yes, I thought that was probably one of the key things. How did you say that Erik Menendez, when your father would want to take him into the bedroom, sometimes he would run away and fight? Miss Aronson says, objection misstates the testimony. Court says, overruled. The witness says, fight? You mean fist fight? How would you want me to define the word fight? Mr. Khan says, I asked you if you testified in this courtroom this morning that sometimes you saw Erik Menendez rebel by running away and fighting with his father. He'd run away and hide underneath the dining room table or just run away from him. I'm talking about in this courtroom this morning, you used the word fight. I may have. Can you tell us what you meant by that when you used the word this morning? He didn't want to go in the room. And what do you mean by fight? He struggled. He just didn't want to go. Struggled in what way? Miss Aronson says, could the witness, the court says, let's, in the future, Mr. Khan, let him finish his answer before you ask the next question. Mr. Khan says, yes, Your Honor. The witness says, when Jose would have him by the bicep, bringing him to the room, he would be trying to pull away from his father. Now, you report to your own home beatings with the belt on Erik for Lyle Menendez by the father? I never discussed it with my parents. Is there a reason why you kept this secret all these years? Object to the form of the question, says Abramson. Rephrase the question, says the court. Mr. Khan says, did you tell anyone that Erik and Lyle Menendez are being struck too much with a belt in their own home? Did you ever tell anyone that? Not my parents, but yes, I did tell somebody. Who did you tell? I told friends of mine where I lived when I got back because they were under the same scenario as I just came from. They were living in a similar situation? Correct. Did they kill their parents? Objection, Your Honor. The court says sustained. Mr. Khan says, can you tell us why? Were you very offended when you saw how often the defendants were struck with a belt by their father? Yes, I was. Can you tell us why if you were so offended that you didn't report this to your father or any responsible adult? Because I reported it to Kitty. And Kitty did nothing? Kitty did nothing. That's an understatement. When you reported it to her, you didn't have to report it to her because you're saying the sound of beating was so loud Kitty used to turn up the TV. Correct. Why did you report it to her? Didn't you realize she was aware? I knew she was aware. I asked her why. No answer was given. That was Jose's discipline. Is that what you meant by reported? You asked her why? Mm-hmm. And so did you feel that Kitty was also being cruel with her sons by allowing that to happen? I gave that thought, yes. Did you reach that conclusion that she was being as mean as Jose was, but she wasn't inflicting the pain? Uh, sorry, that was the answer. She asked, "Did you reach that conclusion?" He says that she was being as mean as Jose was, but she wasn't inflicting the pain. So she was as cruel verbally, but she wasn't the one beating them. So she wasn't physically beating them, but just verbally she was just as cruel as Jose. That was the conclusion that you reached? Why she wasn't defending her children, he says. I'm asking you if that is the conclusion you reached, yes or no? Yes. Okay, so when you reached that conclusion, did you decide to report this to your father or some other responsible adult? No, I did not. Can you tell us why you did not? Because I felt they wouldn't listen to me. And why did you feel that your own father wouldn't listen to you, Mr. Anderson? Because of the type of relationship my father and I had. Did you have a relationship with your mother that you felt that you could report to her that Erik and Lyle Menendez were being struck too often with a belt? No. Did you have that relationship with any adult, Mr. Anderson? No, besides Kitty. What do you mean besides Kitty? I asked her why Jose was so mean with the boys. I'm asking you if you had that kind of relationship with any other adult other than Kitty that you felt you could report this. At the age I was, no, I did not. Did you talk to Lyle Menendez since he's been in custody? Since he's been initially arrested? Yes, I've talked to Lyle. Can you tell us how often you spoke to Lyle Menendez since he's been in custody? No, I don't have an exact number. Well, when was the last time you spoke to him? Briefly, the last time I talked with him? Yes, would be Sunday. And did he bring up the $8,000? No, sir. And was that the first time that you ever visited him in jail this Sunday? I didn't. Miss Abramson says objection misstates his testimony. The court says, wait, there's an objection here. Miss Abramson says misstates the testimony. The court says rephrase the question. The answer is stricken. Mr. Khan says, did you visit him in jail on Sunday? No, sir. Talk to him over the telephone? Yes, sir. Have you ever visited him in jail? Yes, sir. How many times? Once. When was that? The last time that I testified. So the first trial. How often have you spoken to him on the telephone? Since the last time I testified? Yes. Oh, maybe 4 or 5 times. And of any of those occasions, did you ever bring up the $8,500? No. All right, thank you. I have no further questions. The court says redirect. So this is redirect for Erik. So Ms. Abramson asks, well, Mr. Anderson, does it now appear that Mr. Khan has the interview notes from when we interviewed you in 92 in Oak Lawn? Yes, it became very apparent. And that was about a 6 or 7 page report full of information. What? The report that Mr. Khan says objection calls for speculation as to what's included and what was not included in the report. The court says, well, I don't know if he's seen it or not. Ms. Abramson says, you've seen the report that was made of our interviews with you, haven't you, at some point? Yes. And it was a 5, 6, 7 page long report? Objection calls for speculation and vague. Ms. Abramson says, I'm asking what he understands. Overruled. The witness says, it was longer than 5 or 6 pages. Ms. Abramson says, and when we came, we being myself and Ms. Lansing, when we came to, you're right. When we, Mr. Khan says, I'm going to object and ask to strike counsel's comment. The court says, let's not make remarks, counsel. Just ask questions, Ms. Abramson. She says, and when when Ms. Lansing and I came to Oak Lawn in 1992, did we ask you basically to tell us everything you could remember? To the best of my ability. And that was it. To the best of my ability. Everything you could remember about every member of your own family and the Menendez family. Objection. Correct, says Ms. Abramson. Mr. Khan says, objection irrelevant, calls for hearsay. The court says overruled. Ms. Abramson says, correct? Yes. And we just asked you to tell us everything about what Kitty Menendez and Jose Menendez were like and everything about what their children were like. Objection leaning. Sustained. Ms. Abramson says, did we ask you to just tell us everything you can remember about those 4 people and how they interacted with each other? Yes, you did. We didn't ask you just a specific questions, run away and cover our ears and not hear what you wanted to say, did we? No. And you testified for a day and a half at the last trial, did you not? Yes. A full day and a half? Yes. About more topics than you testified to about here. Correct. And you were cross-examined by the previous prosecutors, were you not? Yes. And you didn't refuse to answer any questions that those prosecutors put to you on the witness stand, did you? No. So he fully cooperated in the first trial, is what she's trying to lay out. It wasn't until the second trial that he decided, I'm done talking to you people. So are you willing to answer any questions that Mr. Khan wants to put to you on the witness stand here? Are you not? Yes. Now, Mr. Khan asked you if you thought the way Jose Menendez treated his children was cruel. Do you remember that question? Yes. Objection misstates the testimony. Sustained. Ms. Abramson says he asked you if you asked was Jose mean with the boys, correct? Objection misstates the testimony. Sustained. Ms. Abramson says, were you offended by what Mr. Menendez was doing with his children? Yes. Were you offended by what Mrs. Menendez was doing with her children? Yes. Did you see any beltings done, any strappings with the belt of Lyle Menendez when he was an infant? No. So the month that you spent in Cedar Grove, New Jersey, Lyle Menendez was what, between 1 and 2 years old? Yes, that would be about right. You didn't claim anybody hit him with a belt when he was 1 or 2 years old? No, I never saw it. That was his first time to the Menendez family back in the 70s. So then in 75, were you spending your summer school vacation with the family Menendez? With the Menendez family? Yes. How many months did they give you off the school? How many months did they give you off of school in Oak Lawn, Illinois? We got off in June and June, July, August, and we were back in September. So it would be like 3.5 months. Did you get off in the beginning of June, the middle of June, or the end of June? Beginning of June. Short school year? Yeah. So that would have given you 3 months in the summer. Yes. Did you spend 3 months in 75? Yes. And then did you have the same schedule in 77, 3 months off? Yes. Okay, so that's 6 months between those 2 years? Yes. Did you observe this strapping with the belt as much in 75 just as much in 75 as in 77? No. Was it more in 77? Yes. Were there any strappings with the belt that you remember in 75? Minimal. How many times, just roughly, do you think either of the children were strapped with a belt in 75? It was very infrequent. It was so infrequent that I could just say maybe 5 times the whole summer. but more frequent than when the children were a little older in 77? Yes. So when Lyle was an infant in 70, he didn't see any beatings. When Lyle was around 9 in 75, yes, there he saw a few. He categorizes it as maybe 5 during that whole summer. And then when he comes back in 77 and Lyle is a little bit older, so maybe 11 at that point, right? Um they're seeing he sees frequent beatings, like he said, every week at least. Is it in 77 that you believed it happened at least once a week, perhaps more? Correct. If I were to suggest to you, Mr. Anderson, that there are 12 weeks in a 3-month period, okay? Okay. And if you had a recollection of 12 to 15 times, yes, would that equal once a week? Yes. So he wasn't off in his estimate. Now, I want to talk to you about what Mr. Menendez was like in 1977. You saw him being less outgoing, you've told us. Yes. More introverted, alone, withdrawn? Yes. Did he also start demonstrating these uncontrollable these angers that you've described? Yes. Would there be anything that would prompt these uncontrollable actions on his part, or would it just happen? It would just happen. And what would he do in these? You said he would destroy a toy or take it out on a tree. Anything else that he seemed destructive with? Paper. What would he do with the paper? Wrinkle it, rip it. And while he was wrinkling and ripping the paper, what was he making noise? He'd be, yes, yes. Was he yelling, screaming, crying? It was doing what he was doing. Yes. Did you notice what he'd start with? Or did you notice when he'd start with these episodes, whether he seemed angry or upset? Yeah, it would catch my eye immediately. The noise was right there. So he started making a great deal of noise? Yes. Even if no one had done or said anything? No, that was the strange thing about it. When he's having one of these episodes, did you see what his father did to him? Yes. How would his father deal? Let's focus on, do you have a recollection of the times where Erik would be ripping or tearing paper and making these noises? Okay. Do you have a recollection of? Yeah, of him doing it? Yes. Did you ever see Jose Menendez get physical with Erik during one of these episodes? Objection, irrelevant, and beyond the scope of direct. Court says sustained. Ms. Abramson says, well, I'd like to be heard on this, that is, in response to something brought out on cross. The court says you'd have to get more specific than that. It wasn't brought out on cross in that fashion. Ms. Abramson says, did you ever see Jose slap and hit Erik Menendez when Erik was having one of these rages, taking it out on the paper? Yes. When Jose Menendez would slap and hit Erik Menendez, would Erik stop or would he get more upset? More upset. After Erik Menendez got more upset, what, if anything, would Jose Menendez do to him? Slap him on the hand or the ass. And then what would he do? Take him to his room and close the door. Take him forcibly? Yes. Now, you indicated that as a result of the rock incident, you were locked into your room for so long that you were forced to urinate out the window, correct? Correct. How long were you locked up? The whole day, night, and into the morning of the next day. Once Jose went to work, then Kitty let me out. When you observed Erik Menendez being taken to his room, would he be locked in his room for the whole day? It would happen. Those urges would happen mostly in the evening, so that would be like his bedtime. He'd be in the room for the night for the night. Did you see him being disciplined by being sent to his room and locked in his room on other occasions? Yeah, that was Jose's form. Yes. What was a standard discipline? Was that a standard discipline in addition to the belt? Yes. And when Eric Menendez was locked in his room as discipline, how long would he be required to be locked in there? Till the next day. Until the next day? Yes. And was that true only in 77 or was it also true in 75? That was the punishment in 75. So at 4 3/4, he'd be locked in his room all day into the next day? Correct. As I said, okay, go ahead. I'm sorry. So at 4 years old, close to 6, he's being locked in his room all day. I don't know about you, but I think 5 6-year-olds need to be watched and attended to all the time because they get into everything. That's like the perfect time where they can get into trouble if they're not supervised by an adult. So they just leave him in his room, lock him in there as punishment at 5 years old. God, that's horrible. Okay, as I said, go ahead, he says. Well, let's talk about, if I can, the rock incident for a moment. Did you purposely hit Lyle Menendez in the face with a rock? No. Well, how did it happen? It started out to where I threw a rock at the ground at Lyle, which, not even to hit him, just threw it at the ground. Lyle then picked up a rock and threw one back at me at the ground. Then it escalated into a competition thing like everything that him and I ever did. Trying to what? See who could throw it the closest to each other without hitting? Well, it started out that way, yes. And then it developed into such a frenzy of competition to where we took refuge behind items keep from being hit to keep from being hit because we were purposely trying to hit each other. This is just like a guy thing at that point. It started out as an innocent not wanting to hit each other and then grew into purposely trying to hit each other with these rocks. The rock that struck him, how did that come about? A direct hit or ricocheted? On my part, I faked a throw. He ducked between the doghouse, and when he brought his head back up, I threw at the doghouse and it ricocheted and hit him in the face. Okay, you indicated the punishment for you was a threat to send you home and then you got locked up for 2 days, right? Day and a half, yeah. What was the punishment for Lyle Menendez for having gotten hit with a rock? He was not hit with the belt or anything. As the boy was sitting there with his skin all swollen and his face all swollen, Jose had a way of talking with the boys to where he got right in their face. He would be very close to where his breath, it would move his hair, and sternly telling the boy that he should not have even participated, should have left the area. So, why would he get involved in something of that nature with a man, a boy my size? So, he was lecturing Lyle. Objection leading. Overruled. Miss Abramson says, and in the course of, so we didn't answer the question. In the course of the lecture, was he blaming Lyle for having gotten his eye injured? Yes. And was Lyle's eye very swollen and puffed out? Oh, yes, immensely. Yes. And you indicated in response to questions from Mr. Khan that the parents said they were concerned about whether he would be able to see. Yes, that was Kitty. And then Jose also said the same thing later when he came from home, when he came home from work that night. Now, how old was Lyle at that point? 9, 10. He was, and didn't either Mr. or Mrs. Menendez express concern that you may have endangered Lyle's professional tennis career? Oh, yes. Jose made that quite clear. What did he say? That I would be in a lot of trouble if after the swelling went down and he was able to see it, if it interfered, him and my father would have a conversation as to how the situation would be handled. Well, what did he have to say about Lyle's tennis career? that he hopes that after the swelling goes down, it doesn't interfere with all the time that he has put into training Lyle. Training him to do what? Play tennis professionally. And this is about a 9-year-old child? Yes. And when the swelling went down, was it obvious that Lyle's eye itself had actually not been hurt? Correct. And before the swelling went down, was Kitty Menendez trying to cut Lyle's swelling open with a razor blade to get the blood to come out? Yes, the scenario that happened there was while in the kitchen, Kitty was in a kind of freaking out. She was excited. She was very excited about what happened and looked at me and told me where a razor blade was and told me to get it because she wanted to relieve the pressure in the swelling, and I refused to get it. I told her, "You don't want to do that." How did Lyle respond? Oh, just he was hysterical. Didn't even want his mother playing doctor on him with a razor blade and even touching the area with it. Was it you indicated in response to questions from Mr. Khan that you were never struck with a belt by Jose? That's correct. Even though you misbehaved more than the children did. That's correct. Did you see them getting struck with a belt for things that you did? I never saw them get hit with a belt, but I heard them. Yes, I heard them. Yes. And did in fact Lyle come to you and ask you why was it that he was being hit and you were not for the same behaviors? Objection irrelevant and beyond the scope. Sustained. Ms. Abramson says, did you ever ask your aunt, Mrs. Menendez, why are the boys being hit for what I'm doing? In a roundabout way, not directly. That type of answer, but I asked why were they severely punished for stupid things, and I myself was just sent to my room and was yelled at, but I was nowhere near as physically contacted with as the boys were. Her answer back to me, objection, irrelevant, and calls for hearsay. Sustained to the rest of the answer, he answered the question. Ms. Abramson says, when you've indicated that you were unhappy, that you couldn't go back and spend more time with your cousins, was that because you had so much fun at their house? No. Why was it that you wanted to be back with him? Because I wanted to see if the same thing happened at a second trip. I didn't believe what I saw when I was there. Did you try to comfort your cousins when you saw them being treated in ways that you considered the best that I could? And did you want to be there for them? Yes. Now, when you borrowed this money from Lyle Menendez, did you have health insurance? No, ma'am. Did you have any way to pay this medical bill? No. Do you have children? Yes. Did you have Did you have these little children back in 1990? Yes. Had you asked and been refused by your own wealthy father for this money? Yes. Objection irrelevant. Witness says yes. Sustained. The answer stricken, says the court. Miss Abramson says, when you borrowed the money from Lyle Menendez, he was not under arrest, was he? No. You didn't know he was going to be arrested? No. You had no information that he had participated in killing his parents? No. You don't make a great deal of money, do you, Mr. Anderson? I'm the only source of income for my family. No, I do not. Your wife is not working? No. Objection. Irrelevant, says Mr. Khan. The court says overruled. The answer will stand. Ms. Abramson says, and you receive no help from your family, is that correct? No. Objection irrelevant. Motion to strike. Non-responsive. The court says, sustain. The answer stricken. Ms. Abramson says, Mr. Khan asked you why you wouldn't go to your own parents to complain about the physical violence in the Menendez family. Remember that? Yes. Was there physical violence in your own family? Yes. By your father to your mother? Yes. By your father to you? Yes. So you didn't think that was a warm and cozy environment to talk about this in? Correct. Nothing further, says Miss Abramson. The court says, all right, Mr. Gessler, anything else? Yes, I do, Your Honor. So we're going to have redirect by Lyle now. Mr. Gessler asks, Mr. Anderson, when was it that you had your appendicitis operation? In November '89. November 89. Or, all right, yeah. And at that time, did you have medical insurance or some way to cover the surgery? No. How much did you owe on that bill? Almost $11,000. And who did you owe it to? The doctors and the hospital. That's a bunch of garbage. Insurance is such a scam. What was that in the Chicago area? Suburbs, yes. Had you been billed for that? Yes. And that time, did you go to your father or did you go to your family to see if they could help you with that bill? Yes. Did they help you? Refused. Shortly after that, did you see Lyle Menendez on some occasion? At my brother's wedding. When was that? February of 1990. And at that time, did you discuss with Lyle Menendez the predicament that you were in? Correct. Did you ask him for money at that time? I asked. I told him that I've exhausted all efforts of who I thought was close to me to give me the money and that they weren't forgiving. They weren't giving it up. And I asked him and I knew. I told him, I know it's a bad time and what's happened to your parents. I said I'm really in a bind. And he told me that he would help me only with $8,500. How did he say he would help you out? By sending me the money. Did he do so? Yes. Was it all in a check or was it in some different form? No, it was in two forms. It was a check for 8,050 and cash of 450. At the time, did he send you any note of memorandum as to the amount that he sent you? Yes, he did. And also end it with good luck and signed it. At the time, was there any arrangement you had with Lyle Menendez as to whether the money was to be paid back? At that time, we tentatively discussed $100 a month, which I told him I could not afford. At that point, he said, come up with a payment schedule that will best fit your ability to pay me back. Time was not a factor. It was just a matter of man to man paying the debt back, and I could not, at the time, when I was coming up with that figure, he was then arrested. So they never even worked out a payment plan. So during that period of time, did you have any other family needs for one of your children? Yes. What was that? Objection. Irrelevant. Sustained. Mr. Gessler says, Was there some difficulty in paying the $100 a month back to Lyle Menendez because of other medical financial obligations you had? Objection. Irrelevant, says Mr. Khan. The witness says yes. The court says objection sustained, the answer stricken. Just rephrase the question as to whether he had difficulties paying it back. Did you have some difficulty paying it back? Yes. What was that difficulty? Objection irrelevant. Sustained. As to the reason, says the court, we don't need to know why he can't pay it. We just need to know he couldn't, apparently. Mr. Gessler says, did you explain to Lyle Menendez the nature of the difficulty with trying to pay the money back? Yes. What did you tell him? I was. Mr. Khan says, objection irrelevant, calls for hearsay. The court says overruled. The witness says, I was jobless. I was between jobs. Hence, why he probably didn't have health insurance at the time. Mr. Gessler says, was there any other difficulty that you... Objection, says Mr. Khan. The court says overruled. The witness says, yes. Mr. Gessler says, what was that difficulty? My daughter was dying. My daughter was dying. What kind of... She has HUS, hemeliac uremic syndrome. It's a form of the E. coli bacteria virus. Did you tell that to Lyle Menendez also? Yes. What was his response? Objection, irrelevant, overruled, says the court. The witness says he was in awe and extremely sympathetic to the fact that he did not know because I was the first to tell him. At that point, what did he say about the money that you had borrowed from him? The best that given the $100 was discussed, that's when the process of what I could afford came up, what I could afford, came up with a payment schedule and the best fit my ability to pay it back to him, and to make whatever figure I came up with, he would not hold me to it because there would be months where things would be different, of course, he knew in my life. So if we agreed on 20 and I could afford $20 or $10 as long as the denomination came forth. That was in early 1990? Yes. Did he ever press you for that money? Never. Since that time in 1990, when you told him of your daughter's condition, has he ever pressed you for that money? Never brought it up. Now, you testified at the first trial? Yes. And between the time that he lent you the money and the first trial, did he ever tell you, look, remember that money that I lent you in order to try to get favorable? He never discussed it, says the witness. After the first trial, did he ever say, gee, thanks a lot for what you said for me, and we're going to forgive that money I lent you when you needed it? He's never told me that he's forgotten about it. Is your arrangement, as far as you know, gee, I'll pay you what I can when I can? Correct. Between the first trial and now, has Lyle Menendez ever said, I want you to testify to the same things, and then I'll forget about that money you owe me? No. Are you testifying the way you are today because Lyle Menendez was kind to you, or are you testifying because it's the truth? It's the truth. As to the rock incident, you said that it ricocheted off the doghouse and hit Lyle Menendez in the eye area there. Yes. Was his father home at the time that that incident occurred? No. How much after the incident did his father come home? This happened just after lunch, so Jose came home actually, or usually around 5 or 6. That was several hours later. Court says, let me ask you how much longer you'll be, Mr. Gessler, because we have a juror that has to leave. 5 more minutes, says Mr. Gessler. The court says she has to get going on the road. So we'll recess and we'll resume tomorrow at 8:30. Don't discuss the matter with anyone and don't form any final opinions about it. One of the jurors has a medical appointment, so we'll take our break and resume tomorrow at 8:30. The jury exits the courtroom, and now there's some discussion outside of their presence. The court says we'll take a short recess and then we'll discuss the next witness. Who's that going to be? Ms. Abramson says Diane Vandermolen, Your Honor. Court says we'll discuss her testimony after a break. We'll resume at 25 minutes too. Ms. Abramson says, thank you, Your Honor. Now they leave and they come back. This is again outside the presence of the jury. Jury went home. Court says, as far as the testimony of the next witness, Diane Vandermolen, people have filed objections. They filed those before a motion was filed by the defense or the memorandum was filed by the defense. Who's going to be examining this witness? I am, Your Honor, says Ms. Abramson. Ms. Towery says, and I am on behalf of Lyle Menendez, Your Honor. The court says, okay, what's your offer here as to the witness? Ms. Abramson says, all right, well, there's a number of things, Your Honor, and they fill 2 categories generally. One is a category of physical violence, but the other is all other things that would corroborate Erik Menendez's testimony concerning his state of mind at the time of the crime, his behavior, and his thought process during the week preceding the incident. Just to give the court just a tiny bit of background before I go through these things individually, this witness was with the family during the summer of 1976, for the summer of 1978, for 2 weeks in the summer of 1979, and then for a continuous 13-month period from June 1st, 1982 through July 1983. And most of what I'm going to be eliciting from the witness concerns that trip in 82 to 83. What we're trying to do is show continuums, if you will, in behaviors by the parents, but also additional behaviors that we believe by both the parents and the children that are relevant to the issues raised by the molestation, the fear of the parents' reaction to the threat that they would expose it, their knowledge of how their parents would deal with so enormous a scandal, and their justifiable fear, or my client's justifiable fear, that his mother would not only fail to protect him from his father, but would join in any action necessary to keep him from revealing the family secrets. So let me just a few specific things my client said this witness can corroborate. Let me go through a few of those and I'll give the court the dates. During the 1982 through 83 year, the witness remembers that my client calls himself Hurt Man and that Mr. Menendez testified that that was the name that he gave himself after the torturous sexual activity began, and this corroborates and corresponds with that time period in his life. That was testified to in the first trial, where Lyle referred to himself as Hurt Man. This was during the ages when he was being molested by his father. I take it the court is issuing a basic blanket ruling that whatever injuries Jose Menendez inflicted on Kitty Menendez, the court does not consider relevant. This witness remembers not only that Kitty Menendez had numerous bruises, but that Jose Menendez made a comment about them, claiming that Mrs. Menendez was, quote, accident prone. So he was beating her as well. She was having bruises, or she was seen with bruises, and Mrs. Menendez said that she was accident prone, claiming that's why she had all the bruises. The court says, I had no blanket ruling, but I'll rule. Ms. Abramson says, we're offering that from the 1982-83 period just so the court has a list. Court says, I'm ruling on everything as it's offered. I'm not making any blanket statements. Let me just make some notes here. All right, says Ms. Abramson. The court says, okay. Ms. Andersen says, with respect to my client's testimony that he had these frequent nightmares and was afraid to go to sleep and would require the drawers and the closet to be checked, the court may recall that Erik Menendez testified specifically to a terrorizing behavior by his parents where they planted the fright mask in the closet. Okay, that was it. They talked about this earlier on I think it was in testimony where they purposely would scare the boys when they were young. They would laugh, they would get a good kick out of it. They would leave the house and leave them home alone and like act like somebody was trying to get in the home. Like they would do like legit terrorizing things to scare the boys. It wasn't just like a tiny little prank where I hid your toy and whatever. It was like mean-spirited things like hiding a frightening mask that would your son's going to react to and scream and cry at. That's the kind of stuff that Jose and Kitty did. She continues on and says, with this witness, Ms. Vandermolen can testify to is she was aware that Erik Menendez was having frequent nightmares and he would refuse to go to sleep until someone checked through the drawers, and especially by the time of 82, 83, when he's 12 and 13, he asked her to bring Lyle Menendez in to check through the drawers and the closet. And I think that corroborates, number one, that he had these fears, and number two, that he is not asking his parents to check for these things at this point, but instead is asking his brother, which is very telling that he no longer trusts his parents. He doesn't trust that he can go to his parents for any form of protection anymore because they will laugh at him and tell him he's, a wuss or whatever. Like they would tell him, don't cry, don't be scared. And Jose was very much the tough love approach, but when I say tough love, it's like to the max where it's abusive. So think of it that way. So that is one of the themes through this witness testimony, which I think there's only two examples we're going to ask about of where Erik Menendez sought protection from Lyle Menendez, and we think that's relevant to the events of the last week. That's why he went and sought Lyle's help in this situation right before the crimes happened. Let me just say the other event would be that Lyle Menendez during the 82-83 period would take the blame from Mrs. Menendez for certain minor transgressions that Erik Menendez committed, such as tracking snow in the house or allowing the ferret to run loose and to spare Erik her anger and wrath. Lyle took the blame for those things, claimed he did things when Erik had done them. The next thing that Diane Vandermolen can testify to is her recollection of the time that Erik Menendez ran away by taking the canoe, and we think that effort on his part to run away is extremely significant, particularly given the cross-examination she testified to that at the last trial. As I indicated previously with the previous witness, the witness has a recollection of, by 82-83, very frequent rages of Kitty Menendez, in which Mrs. Menendez expressed to her children, "I wish you were never born and I hate you." She also recalls in 1982 a number of occasions in 82 and 83 when Jose Menendez would send Erik Menendez up to his room ostensibly to do homework, and Jose Menendez would say, "I'll be there in a little while to help you," and that Jose Menendez would indeed go to Erik's room, emerge some hours later, and announced that Erik Menendez was not feeling well and would not be eating dinner. In addition, the witness remembers some occasions following one of these private meetings upstairs in the Pennington house when, although Erik Menendez would come down for dinner, he didn't eat. He was extremely withdrawn and quiet and appeared sad or disturbed. How could Kitty just how could Kitty sit there and watch her sons act that way, be that, hurt, dejected, feeling withdrawn and quiet, and how could she watch her sons go from these, happy-go-lucky boys to suddenly being this withdrawn kid who doesn't want to talk, and especially after these belt beatings that she was very much aware of because she would turn the TV up so that Brian Andersen didn't hear the belt beatings. She had to have known about the belt beatings. She would inspect them. Remember, she used to inspect Erik's genitals after he would shower and things to make sure, I don't know what. So anyways, all of that to say, it's just too much. And how could she sit there and allow that to happen to her kids and not only not protect them but partake in it? It's insane to me. Everyone's like, "Well, how could they kill their mom?" How could she be such an evil, horrid person to her children is what I want to know. Not how could they shoot mom, but how could mom be so awful to her kids? That's my question. But anyways, let's continue on with Ms. Abramson's arguments. She says, "I assume the court is not going to permit, even with respect to 82-83, this very intense confrontational quizzing at dinner. If the court were to allow it, we would offer very brief testimony on that. I would like to get in by this point because it applies to my client as well in 82 and 83 that my client's all of his time was structured, as he testified, all of his time was structured by his parents. Every free moment was involved with sports, specifically by this time, tennis. He had no friends, he had no playtime. His life was completely controlled by his parents. I think that's very relevant to why he was so helpless and dependent that he couldn't think of a way out of the crisis in 1989. The witness will testify that the showering together, now that the brothers are 12 to 13 and 15 to 16, all three are still showering together, they with their father. In addition, the witness will testify that starting on earlier visits, but just as frequent in 82 and 83, the brothers took turns sleeping in the same bed with their mother. And I think Mr. Gessler has an argument as to, I think I understand their argument. It's, if they want, I can paraphrase it now, but it was to do with the fact that the prosecution elicited from Jamie Pisarcik the fact that when Lyle Menendez told her that he and his brother were responsible, or that he was responsible, is the way the evidence came in, or for the killing of his parents. He told her that the father was molesting Erik and the mother was molesting him. And the people sought to put that in and no doubt will argue that the molestation accusation towards the mother is not true. And he testified to that in detail. There's no way he was faking that. And this is some evidence to support it when you're dealing with someone who's 15 and 16 years old and sleeping with his mother. These are on occasions when the father is not home. Let me go on. To corroborate my client's testimony about how he was groomed for sexual cooperation with Jose Menendez, this witness would testify that in 82, 83 specifically, she remembers, well, she actually remembers it earlier, but she has more specific memories of following the showers together. Mr. Menendez would sit with both of his children alone in the den, talking for several hours about history, specifically Roman history, and how Roman soldiers behaved, although she does not recall any discussion of sex among the soldiers. But that's what he would say, is that it's very common for Roman soldiers to just have sex with other Roman soldiers, even if they were of the same gender. So although she does not recall any discussion of sex with the soldiers, there was a great deal of lecturing about how Romans were a model and how they should pattern themselves after the Romans. A slight flaw, perhaps, in Mr. Menendez's classical history, but nevertheless, it was the Greeks, after all, in any event. The witness would offer that from the beginning of her interaction with this family, but still, and for our purposes, most particularly relevant in 82 and 83, Erik Menendez would show visible signs of being frightened by his father by crying when he was frightened by him, either verbally or physically, and that she was prevented, she, the witness, from trying to comfort Erik Menendez when he was fearful and crying by Mrs. Menendez, who told the witness that she was not to hug Erik. That would make him too much of a baby. Wow. If you don't hate these parents enough, there's more reasons to hate them. I mean, not hate, but like hate their actions, hate their behaviors, hate the monsters that they could be. Because I'm sure maybe they had some good qualities. I'm sure if you ask Erik and Lyle, they probably thought, yeah, our parents had some good qualities. But it's hard to see that as an outsider when you're looking at all the horrific things that they did to their children. The witness would testify that starting in 82 through 83, Mrs. Menendez was seen frequently in sessions, ostensibly to tutor Erik Menendez, where she was extremely hostile and critical. And when she got frustrated, she would hit him repeatedly on the head, calling him dummy, stupid, and dumb bastard. I should indicate that Dr. Wilson will testify that based on the records that we have, there was a report from a psychologist dated 1980 that showed that Erik Menendez had learning disabilities, particularly in following oral instructions. And so this behavior by the mother is following her having been informed that he has these learning disabilities. So she's still making him feel stupid, knowing that he struggles to learn properly, anyways. And I think that shows particular cruelty. And as part of these tutoring sessions, the witness actually saw Mrs. Menendez timing Erik Menendez with a stopwatch. Related to this, but slightly different, has to do with how Erik Menendez and Lyle Menendez were specifically drilled by their mothers on the subject of keeping secrets from other relatives. The witness will testify that on a number of occasions, she sat down with the defendants and Mrs. Menendez would go over a list of things in anticipation of a holiday gathering with the rest of the family that none of them were to be permitted to talk about. And one of the things that was constantly emphasized was the fact that Erik had not gotten into PDS a number of times, that he was held back a grade, that he required remedial classes, but they weren't giving them to him, and Erik Menendez was specifically instructed never to tell any members of his family that what was going on in the home about those issues or about sports issues or anything personal. Mr. Khan, in cross-examining Erik Menendez, asked repeatedly why Erik did not bring up as a topic of conversation with his parents the fact that he would have liked it better if the molestation had stopped, or that they should having a major crisis that week. He just, yeah, he was like, did you ever just tell him you wanted it to stop? Did you ever just think of leaving the home? That just proves he knows nothing about abuse victims. The witness, over the course of her living with the family, so Diane Vandermolen, and particularly in 82 and 83, would testify, if permitted, that the way Mrs. Menendez controlled all conversations in the home, that she never saw either of the sons bring up any topic of the conversation with either parent. That all conversations among them and the parents was determined by the parents setting the agenda, particularly Mr. Menendez. That if you tried to bring something up that Mr. Menendez didn't want to, he would be insulting and demeaning and angry. The witness would also testify that at no time did either of the Menendez children complain to her about their parents or their treatment by their parents or criticize their parents to her or to the parents. And I think that has to do with the prosecution's obvious theory that there's hatred there, here and there, and that there's, okay, let me back up. Now I get it. Okay. Sometimes just the way we talk and the way actual English phrases should be said just don't make a whole lot of sense, or they just throw me off. Sorry. Anyway, she says, and I think that that has to do with the prosecution's obvious theory that there's hatred here, and there are a complete dearth of witnesses which will prove that. So a ton of witnesses will say that there was no hatred there. I just have a lot of notes here, Your Honor. Just bear with me. There's a continuation into the 82-83 period here of Mrs. Menendez threatening Erik Menendez that she was going to report his behaviors or commission and omissions to Jose when he got there. And this witness remembers Erik Menendez begging her not to tell Dad certain things. These are among minor things. There's an incident where Jose Menendez pretended to be a burglar banging on the door, and the witness will describe the terror that's engendered in both Erik and Lyle, in that it was a very long, drawn out charade until Mr. Menendez identified himself. So it went on for much longer than it should have. So not only did they do this thing where they just terrified the boys for no reason by pretending that they were a burglar, in Diane's opinion, it went on way too long. The witness is permitted, the witness, if permitted, would testify to overhearing Mrs. Menendez, well, two aspects. That she was both told privately and overheard Mrs. Menendez saying to the children that one shouldn't have children, that they drive a wedge between a man and his wife. When she said this, or words to this effect, to her own children, she was very angry. When she said it privately to the witness, she was trying to give the witness life advice. On the isolation issue, well, two things. The witness would say that she never saw any playmates for either of the children, with the obvious and notable exception of Andy Cano, who she observed being Erik Menendez's friend, a close friend, someone who stayed over a few times at the Menendez home. Also a cousin. Peter and Marta Cano are Andy Cano's parents. A close friend who stayed with them. Okay. The witness can document Mrs. Menendez's excessive drinking beginning in the 82-83 period, not the drinking beginning, the excessive drinking beginning at that time. She is very specific, knows precisely what it was Mrs. Menendez drank, would testify she drank every single day around the children. She would testify that she was drinking secretly and trying to keep it from Jose Menendez by 82 and 83. So she was trying to secretly drink, and you know, he had to know. He knew everything that the boys were doing. He had to know that she was drinking too. Maybe she was a little better at hiding her transgressions from Jose, but he probably still had some idea. Miss Abrahamson says that she would drive after drinking to the point where her speech was slurred, and that to the point where she had exaggerated speech and movements, and that she would make efforts to hide the drinking from Mr. Menendez. And when he caught her, which happened more than once, there were arguments about her having filled up the liquor bottles with water to try to conceal her drinking, like a child. This has to do with her secretiveness. I've already talked about Erik Menendez running away. Oh, the witness observed in 1976 Jose Menendez holding Erik underwater by the head, watched. saw Erik Menendez struggling to breathe, gasping and gagging, and looking extremely frightened, flailing his arms, which corroborates the episode that Erik Menendez described, episodes. And she also saw Jose Menendez pulling Erik down to the bottom of the pool by his feet, not letting him go, and how frightening that appeared to be to Erik. This witness was also aware that there had been. Let me see if I can put this together. The court may recall Erik Menendez testified that he was pushed into and pushed through a sliding glass door in the Pennington house. This witness, Ms. Vandermolen, remembers that there was one of those two sliding glass doors. Through the glass, though the glass had been repaired, it didn't work properly, and she was told by Kitty Menendez that Erik had fallen into it and broken it. Let me see if there's anything else. The witness would testify to a dramatic difference in the behavior and demeanor of both Erik and Lyle when the parents were around, both parents or both versus when they were alone with her, when they were alone with Kitty versus when the two of them were together, or if they were just alone. And the difference, obviously, is they'd be fearful, intense, and subdued and silent unless talked to around the parents, and they would be more relaxed and talking about their own thoughts and their own feelings with with Diane when the parents were not around. That's what, not when they're alone with Kitty. I misread that. When they're alone with Diane, their demeanor was completely different than when they were around their parents. We are also, let me just check the minor things and then the big thing. The witness is not going to testify to any physical beatings with a belt, but will testify that all punishment by Mr. Menendez of either son always took place behind closed doors. That she did observe disciplinary talks which lasted anywhere from 1 to 2 hours, where Mr. Menendez would be extremely physically close to his sons, drilling them, critiquing them, controlling them. I am omitting, Your Honor, as compared to the previous trial, any efforts to elicit from this witness how she was treated, unless the people open it up, how she was treated, how she felt, how intimidated she was, how upset she was, blah, 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 because I kind of don't think you'd let us, and I'm much more interested in focusing on what I need. So let me just see if there's anything else. Okay, the other thing, of course, the fresh complaint of molestation that was made to the witness by Lyle Menendez. We offer that on behalf of Erik Menendez as corroborating trait of character of Jose Menendez for molesting his sons at a particular age. It's my understanding that Lyle Menendez was 8 years old when this incident was reported to the witness, and that correlates with the time he was at which he is touching my client. So that's worded strangely because Erik is her client, not Lyle. And she's talking about my understanding that Lyle was 8 when this incident was reported. Oh, it's also the time when Jose started touching Erik at that same age, 8 years old. I believe that counsel, that's what she meant. It took me a minute. Sorry. I believe that counsel for Lyle Menendez also seeks admission of that incident, and I would let them argue any further relevance with respect to their client, what their theory of the offer of proof is. Ms. Towery for Lyle now says, first of all, Your Honor, as Mr. Gessler did, I also join in the offer of proof that Ms. Menendez has made on the basis that we are relying on behalf of Lyle Menendez on the testimony of Erik Menendez, just as the defense of Erik Menendez is relaying to that testimony and all evidence which corroborates his testimony we would offer jointly. There have been in one incident, there may have been one incident that Ms. Abramson overlooked according to my notes, and this would primarily relate to Erik Menendez, but on that same basis that I just mentioned, I'm sure that Mrs. Menendez would want to offer that Mrs. Menendez was going into Lyle Menendez's room and reading his letters during the 82 and 83 stay. Yep, says Mrs. Abramson. Ms. Towery says, of the witness at the home. And that obviously corroborates the testimony of Erik Menendez that his parents were surreptitiously spying on him and taping his telephone conversations, and he could not figure out why they had the information that they had. So I would offer that in addition to the list of items that Ms. Abramson has offered, The court says this was Erik Menendez or Lyle Menendez's letters. Lyle's. Lyle's, says both Abramson and Towery. The court says, okay. Ms. Towery says, in addition to joining in her offer with respect to Erik, I would point out that several of the items that she has offered also relate specifically to the defense of Lyle Menendez, most particularly the incident in which Jose Menendez pretended to be a burglar in 82 during the witness's 82-83 stay and was pounding on the door. And what happened in the incident was that the three of the children, or the children and the witness, who were present in the home alone, were so frightened that Lyle Menendez got the family gun from the closet and was stationed to protect Erik Menendez and Diane Vandermeulen from the intruder, who, it turned out, was in fact his father pretending to be a burglar and scaring them purposely. Wow. Just wow. I don't know if I knew that part, that Lyle got out the family gun to protect them. That's pretty crazy to think they were that scared and terrified that, somebody was really there. They must have really been good at like disguising their voices or whatever. She goes on to say, and that's relevant, obviously, because it's an incident that would instill fear in anyone. In fact, did instill fear not only in the witness, but obviously in Erik and Lyle Menendez as well. In addition, it's relevant because Lyle Menendez acted in exactly the same way in 82 and 83 when he did not know who his attacker was, as he did in 89 when he did know, which was their parents. In addition, he would also offer the witness's testimony that neither Erik nor Lyle Menendez ever complained to or about their parents during the time that she was present in the home. We would again offer, I think, that Mr. Gessler refers to as the Jeopardy type dinner table talks on the same basis that Mr. Gessler articulated, and that is that Perry Berman testified about those talks, and in redirect, Ms. Nahara questioning, suggesting that that was an aberration, and Perry Berman did not have knowledge of what happened in the Menendez home on a normal basis. He didn't know that those could be daily. And I think that we should be permitted to show that not only were these Jeopardy dinner conversations, these quizzes at dinner, occurring regularly in the Menendez home, but over a period of years, commencing at the witness's first visit to the home in 76 and were continuing up to the few weeks before the homicides, as Perry Berman testified to. We would also offer Ms. Menendez's rages directed towards Lyle Menendez, which the witness observed, in which Mrs. Menendez said to her son Lyle, "I wish you were never born. You ruined my life." And this would relate specifically to Lyle Menendez's fear of his mother on August 20th, 1989, and his belief that his mother and father could act as a unit, with his mother's loyalty running to the father and not to her sons, which she had done time and time again. Anytime, she was home alone with the brothers, if they got into something or did something that they weren't supposed to, she would tell the father. She was always on Jose's side, no matter what. She didn't act with compassion and softness to her sons like a mother should. We would also offer the witness's testimony that both Erik and Lyle Menendez behaved differently around the parents than they did when they were away from their parents. And she will testify that they acted like normal, happy children when their parents went away, but became stiff and stoic and subdued in the presence of their parents. And that also was something that Perry Berman testified about, a behavior pattern that this witness observed as early as 76, and Perry Berman observed in the years of the homicides. We would also offer the talks with the witness and the Menendez brothers regarding that, and regarding what could and could not be discussed about the family in public or to their relatives. And that, of course, goes to the secrecy of the Menendez parents, their obsession with image, and the belief that the Menendez brothers, that their parents would do anything to avoid disclosure of the sexual molestation of both Erik and Lyle. In addition, and in a different category of evidence, is the evidence which relates to the actual sexual molestation itself, and that would be the fresh complaint which Lyle Menendez made to Diane Vandermolen in '76, in which he disclosed to her that his father had been touching him in an inappropriate and sexual manner, and she reported that to Kitty Menendez. And Kitty Menendez promptly told her that it was not happening and took Lyle away, and that was the end of the conversation, and it was never discussed again. Miss Abramson interjects and says, on that score, Your Honor, also, I think an issue in the case of Erik Menendez's credibility has to do with his mother's admission to him on the Thursday before the homicides that she's, quote, known all along that it was happening, and the fact that Diane Vandermolen told her in '76 corroborates Erik Menendez's testimony and tends in reason to prove that indeed she did know, which I think is a very crucial fact in this case. Whether the jury believes that Mrs. Menendez knew that there was molestation going on in her family and was an accomplice, it is it is not by doing anything about it or confronting her children. I think independently proving the actual molestation, the mere fact that it's been reported to her by someone is putting her on notice and corroborates Erik Menendez's later statement that she actually admitted knowing that Thursday. I'm sorry. Ms. Tower says, I would join in that with respect to Lyle Menendez, Your Honor. In addition to the act of molestation in and of itself is an act of physical violence, which is something that certainly would be fear-inducing in any human being. Also, it goes to Erik Menendez's belief of Erik Menendez when Erik discloses to him that his father had been molesting him at the age of 18. So it's relevant to corroborate Lyle Menendez's belief, honest belief, that in what Erik tells him during the week before August 20th, 1989. It also has the argued in our belief that it relates to the explanations offered by Erik Menendez in his testimony as to the reason why neither of the Menendez brothers disclosed the molestation of either of them to Dr. Oziel on the December 11th tape or at any other time. And obviously, Erik's testimony was that Lyle Menendez was adamant that his family secret not be disclosed, and similarly, Erik Menendez testified with respect to the Brian Eslaminia's letter and indicated that Lyle Menendez's state of mind with respect to that letter was that he was seeking to avoid disclosure of his own sexual molestation. He could not deal with it. Erik was concerned that he was not dealing with that issue, and it was a contained effort on the part of Lyle Menendez to avoid disclosure of this molestation of Lyle by Jose. So, for all these reasons, the fresh complaint relevant on a number of different issues that have been raised in the trial. In addition, Mr. Khan indicated today that the prosecution will be seeking to show in their cross-examination and their evidence in rebuttal that the sexual molestation is not true. I believe I heard him say at some point this morning. So there's still at least the first trial they did say that it didn't happen to in their arguments, but we've already sat through a full entire trial, had a ton of experts and eyewitnesses come forward that spoke to the maltreatment of these boys when they were children, all the way up until they were 18 and 21. We have tons of documented um, statements and things of people who can corroborate the molestation. But the state is still saying it's not true. They're going to rebut it and say that the molestation never happened. I believe I heard him say that at some point this morning we should be permitted to corroborate it, certainly by a fresh complaint by Lyle Menendez when he is 8 years old to his cousin that he's being molested by his father. Finally, we also submitted an argument in our brief with respect to the sexual abuse of Lyle Menendez by his mother, and that issue, as we set forth in the brief, and I don't want to belabor the point, but just very briefly, the prosecution raised the issue that they elicited testimony from Jamie Pisarcik, that Lyle had held up a letter to her in the jail and had admitted to killing his parents, saying that the reason was that Erik was abused sexually by his father and Lyle was abused sexually by his mother. To which disclosure, Jamie Pisarcik responded she did not believe him and broke up with him immediately thereafter. The prosecution undoubtedly will argue that this disclosure, half of the disclosure, was true and half was not. The fact that he killed his parents was true, but the part about both Erik and Lyle being abused by their parents is not true. Given that argument, unless the prosecution indicates that they will concede the truth of those statements, it seems that we should be permitted to corroborate that evidence elicited by the prosecution and show that in fact it's true, and the evidence which Diane Vandermeulen can offer on the evidence that Diane can offer on this issue is her observation of Kitty Menendez indicating again in 1982 to 83 visit that she had to go into the bathroom with Lyle when he would take baths in order to wash his hair and remain in the bathroom with Lyle Menendez with the door closed for the remainder of the bath, some 15 minutes or so, and did that on more than one occasion that this witness was aware of. Secondly, evidence on this issue was relevant in the fact that the Menendez brothers would sleep with their mother on nights that Mr. Menendez was away from home, and in fact would argue over who would be permitted to sleep with her. And Lyle Menendez at that time was age 14 and turned 15. So I think that both of those, the testimony with respect to both of those incidents between Lyle Menendez and his mother, are relevant to the issue of sexual abuse by Kitty Menendez to Lyle Menendez. Court says, okay, anything else? Ms. Towery says, that's my offer with respect to Lyle Menendez, Your Honor. The court says, all right. As to Erik Menendez and Lyle Menendez, and that's it. What's the people's response? Mr. Khan says, once again, we would object to the entirety of this witness's testimony under Evidence Code Section 350 and 352. Once again, we feel that the probative value of any of these items for which the witness is being called is outweighed by the prejudice involved and entitled to the people. They think everything is just not of any probative value. Everything from the first trial, it's not worth getting into. Pretty much the argument for everything. We also believe it would once again involve the confusion. We also believe it would once again involve the confusion of issues before the jury. We think here we are also approaching a new reason for objection. In light of the fact that we have now taken testimony from Alan Andersen, in addition to testimony from Erik Menendez and testimony from an expert witness, and that is that we are reaching a point where the evidence is becoming cumulative. I think that based upon the ground, the court should find additional reasons to exclude the evidence which was not argued in the prosecution's case. Some of the matters which the witness revealed to the jury referring to Mr. Andersen was the result of the court's ruling that certain matters would be presented. However, there were other matters which he seemed to inject before the jury and which are now once again being presented before the jury as matters which counsel would like to present to the jury through the testimony of another witness. I'll go through this list of some of these items. I won't cover every single one of them. I think that between the motion we filed to exclude the testimony of this witness in its entirety and the additional motion which we filed concerning this witness, which I think itemizes these areas which we suppose specific objection to the testimony should be scientific to effectively communicate to the court the people's position in regard to each of these items. But just briefly, we feel that the bruises to Kitty Menendez is totally irrelevant to these proceedings. It doesn't prove that Jose Menendez was the one who inflicted bruises upon Kitty Menendez. And even if it did have a tendency to reason even if it did have a tendency in reason to so prove that it's not relevant to the matters that are before the jury, especially when we consider the consumption of time and the passage of time since that time, since the time that these bruises allegedly took place. Nightmares that Eric Menendez allegedly endured is a matter which he already testified, to which the expert has testified. This witness has no personal knowledge of nightmares. This is beyond the competence of the witness to testify to nightmares, and any testimony concerning nightmares should be permitted. Who in the household took blame for minor transgressions is neither here nor there, has no bearing on the issues that are before the jury, particularly when we consider the passage of time and how old these incidents are. Well, it's just bad facts for the state that there's a pattern of Jose and Kitty mistreating the brothers, beating the brothers with belts, demeaning them, demoralizing them, calling them insulting names, getting physically too close, getting, being in their space physically, touch, putting their hands on them and hurting them. All sorts of things that they have done to misuse or mistreat the brothers here. And it's a pylon. It's everything all added together. You can't just be like, well, these things happened in a vacuum when the defendant was 6 years old. So he's obviously not thinking about that moment when he's about to kill his father. Well, you don't know that. And all of the things that have been embedded into their minds because of all of the trauma that they have endured, the many, many, many instances of trauma, like so many yet you can't even count how many times they've been traumatized. At that point, like, how can you how can anyone defend Jose or anyone else? Or I mean Kitty at this point. And to think that it's just sorry, back to my original point. I kind of lost sight of what I was saying there was that all of these things happened and it's all shaped the way in which I'm sorry, the way in which Lyle or Erik would perceive Jose in a threatening situation, in a situation where they thought that something bad was going to happen to them, bodily harm, physical harm, whatever it might be. And we talked about it on, I think it was the previous stream, how there is basically Kitty and Jose created an environment of terror with all of the different traumatizing things that happen in that house. So you can't just take these few isolated things and say, well, he couldn't have been thinking of those things when he murdered his parents, so it doesn't count. You have to look at his whole upbringing and the way that Jose and Kitty treated the brothers growing up to determine what their state of mind could be, because their state of mind is that Jose and Kitty are terrifying people. They pretend to be burglars to scare the brothers. They hide masks in their closets. They do things to purposely scare the brothers. They are malicious, they're vindictive, they're mean. All of these things are not what a good parent does. And yet, we're still here at this trial and they're still in prison 36 years later. So, whatever. Sorry, let's get back. I went on a total tangent there. So, who in the household took blame for minor transgressions is neither here nor there, has no bearing on the issues that are before this jury, particularly when we consider the passage of time and how these incidents are. The fact Eric Menendez ran away is something that not only did Eric Menendez testify to, not only something that the expert testified to, but it is also one of those matters that Alan Andersen slipped out. He also got that before the jury. So now we have more than sufficient information before the jury that Eric Menendez once ran away. Who cares? Why is that not supposed to come in? Ms. Abramson says, Your Honor, Mr. Andersen wasn't even there that year. He didn't testify to. Mr. Khan says, I'll let the record show it. Ms. Abramson says, he testified he crossed the street. I heard it, says Mr. Khan. Ms. Abramson says, You didn't hear it. Mr. Khan says, We have more than enough information before the jury at this point that Erik Menendez ran away. As far as the rage of Kitty and the specific phrase, I wish you were never born, or words to that effect, this was something that Alan Andersen testified to. It is cumulative at this point, not only because of the testimony of Alan Andersen, but because of the testimony of Erik Menendez and the expert witness, Mr. Wilson, Dr. Wilson. Testimony that of the defendant of Jose Menendez, I'll be in the room in a little while, or testimony that dinner was not eaten because of Erik Menendez going to his room, is once again evidence which is irrelevant, has no tendency in reason to prove that he was molested. But the sheer fact that, or the mere fact that you want it out is proof that it kind of does. It's circumstantial evidence that there was something not appropriate going on in that room. And the fact that you don't want it brought out in trial proves that you know that implication and you're well aware of it and you're trying to keep it out for a reason. For whatever value such evidence has, that testimony has already been presented before the jury, and additional evidence regarding that matter is cumulative at this point and is no more probative than it was originally presented to the jury. That the defendants had a structured time schedule is totally irrelevant to these proceedings. It has no tendency in reason to prove that they were in fear of their parents at the time that they had shot them to death. Much less does it prove battered person syndrome or PTSD or anything of that nature. Mere structure of their time schedules is entirely irrelevant. As far as the showering is concerned, we already heard that from Erik Menendez. We heard that from the last witness who testified, and again, it is something which in and of itself does not prove molestation. If you keep injecting this before the jury, as they are seeking to do, keep presenting it over and over and over again, the jury will think, if we're hearing so much of this, there must be some truth to it. Well, yeah, that's the whole point. Because other witnesses corroborated it. Yes, there must be some truth to it because other witnesses are corroborating it. Is this guy new to lawyering? That's exactly what you're supposed to do. The jury will think if we're hearing so much of this, then it must be true. Yes, exactly. If you hear 3, 4, 6, 8 eyewitnesses that say they heard or saw something similar, then yeah, that's probably true. I would assume that. That's usually how trials work. But anyways, he's new. He's not really, but it seems like he's new. So the fact of the matter is, it has already been presented to the jury. There's no reason to repeatedly present this matter before the jury. Hammering it into their head shouldn't be a substitute for the effectiveness of the evidence since it's before them. Either they accept or reject it at this point. There's no reason to hammer them over the head with it. Tutoring of the defendants following the shower incidents once again has no tendency in reason to prove anything in this case, nor does the fact that the defendants may have slept in their mother's bed. Erik Menendez had an opportunity to relate that to the jury, any sexual molestation by his mother, and he did in fact relate such allegations about his mother. Additional evidence that he did or didn't sleep in his mother's bed on various occasions has no tendency in reason to prove or disprove the molestation. It's just time-consuming, non-probative of the issues before the jury. The fact that Erik Menendez would cry from time to time is simply another effort to obtain the sympathy of the jury for the defendant, a matter which they should not consider. The instructions of Kitty Menendez to this particular eyewitness not hug her son has no bearing upon the defendant's fear that his parents were going to kill him on the 20th. It is probative of any of the issues before the jury. It's not probative of any issues before the jury. We already heard name calling from by the parents to the defendants, and now the defendants once again seek to put more and more name calling before this jury. I think that that particular topic has exhausted itself, and they should not be permitted to give every name in the book simply based upon the theory, well, the jury has not yet heard this name. Let's allow them to hear yet another name allegedly used against the defendants in this case. This guy he knows everything he's arguing here is disingenuous. He knows everything that they're trying to put forward is proof, evidence, circumstantial evidence, but evidence nonetheless that there was some inappropriateness going on in this home. It was definitely not a loving, caring environment. So there's that. He says, simply based on the theory, the jury has not yet heard this name. Let's allow them to hear yet another name, blah, blah, blah. I don't know. They don't want the jury to know that Mrs. Menendez called Erik stupid. The issue has been presented to the jury, and there's no reason to allow further testimony concerning that issue. But that's not true because you do put on witnesses to corroborate other witnesses so that you make sure that the jury understands your witness or that witness was speaking the truth when they said that, even though they might have been challenged on something else when the other person was questioning. So there has to be a way to allow testimony to come in to corroborate what other witnesses are testifying about, but he's saying it shouldn't come in. He says the use of a stopwatch for the homework is entirely irrelevant to the issues that are before the jury and the various ways in which they try to suggest to the jury that this was a secret family and therefore the allegations of molestation must be true, I think prejudices the people because it creates the impression that simply because the victims in this case told their sons or told relatives don't talk about particular things at parties has no tendency in reason to prove that the family was in fact a more secretive family than others. I don't think any family airs their dirty laundry in public, and even if it did prove this family was more secretive than the usual, once again, that has absolutely no bearing upon whether or not the various allegations they choose to make against their parents are true. If that were the case, that merely because the parents were secretive, that would prove that any and all allegations the defendant has to make about their parents are necessarily true, because, after all, maybe that's the reason why they wanted them to keep a secret and not talk about the things at the party. It has no tendency in reason to prove the issues in this case. Whether or not the defendants were the ones who started conversations with their parents as opposed to the parents starting conversations with them is another just journey into trivia, as are many of these incidents. It has no tendency in reason to prove anything. The fact that the defendants made no complaints or criticisms of their parents, at least in the presence of this particular witness, has no tendency in reason to prove that they did not make complaints or criticisms at some other time. Whether they did or didn't is entirely irrelevant. The phrase that children drive a wedge between a man and his wife is a matter which has already been presented, I believe, through the testimony of Erik Menendez, and additional testimony concerning that issue does not have a tendency in reason to prove anything the defendants alleging in this case. We already heard from Alan Andersen concerning the lack of friends who would actually come over and spend time at the house. There's no reason to take additional testimony from additional witnesses on this cumulative issue. As to whether or not friends used to visit and how often friends used to visit, or whether they used to stay over and how long they used to stay over. That kitty may have drank in 82, some 10 years, some 7 years before the killings in this case, has absolutely no bearing upon the behavior of the behavior of the defendant 7 years later. Drunk driving is an allegation that should not be permitted. The prejudice involved in that particular allegation outweighs any probative value, particularly when we consider the passage of time between the allegation and the killings of in this case. That Jose Menendez held Erik Menendez's head underwater and was struggling to breathe is a matter which calls for conjecture on the part of the witness as to what Erik Menendez was attempting or was not attempting to do. At most, she would be able to say that she saw Jose and Erik Menendez in the water. Mr. Menendez already had an opportunity to explain to the jury precisely that what those incidents consisted of, and whether there were witnesses to those particular occasions that he relied upon, and he wasn't able to give the names of any witnesses concerning those incidents. And I would ask that it be excluded under 350 and 352. But we have a witness. She's a witness, but you're not. Why? You didn't even give a reason why she can't corroborate Erik's testimony on it. As far as Erik having fallen into a plate glass and the witness was so informed of it by Kitty Menendez, that matter should be excluded as hearsay. It's inadmissible and irrelevant. That the matter of the defendants would change the manner or behavior, sorry, depending upon whether or not their parents were around at the time is something that is irrelevant. It's common behavior, I think, among many children to behave differently when their parents are around. It has no bearing and tendency in reason to prove any of the issues that are before the jury. He has no argument. He just says it's irrelevant. He just says it's all irrelevant. Well, it's not though if you're talking about a case of abuse. It's all relevant then, right? But according to the state and the judge, no, it's not. Talks between Jose and the defendants are matters which are purely speculative as far as the witness is concerned. There's no reason to believe that those talks held any significance to the defendant. It's certainly not uncommon for a father to talk to his sons. She really can't say more than that, and the rest is speculation and should not be permitted. That Kitty Menendez would allegedly look through the letters of Lyle Menendez does not corroborate the issues that counsel has suggested or tend to corroborate the listening in to the phone calls. There is simply no connection between the two. Talks in the dinner table have been ruled inadmissible at this point, and again, we ask the court to rule that it is admissible under Evidence Code 352. And then we get to probably the one issue for which the defendants are seeking to call the witness above all others, and that is the prior complaint by Lyle Menendez concerning the sexual abuse. And I think that that is the most prejudicial matter that could be presented in this jury. In the absence of testimony of the defendant, Lyle Menendez, there's no reason to present that matter before the jury. It does not corroborate a complaint because we have no complaint to be corroborated at this point in time. I think it was argued that Kitty's knowledge of the complaint would tend to corroborate a belief by Erik Menendez concerning whether or not his mother knew that they had been abused. And I would submit that the state of mind of Erik Menendez is the state of mind of Erik Menendez, regardless of what was told and what was not told to Kitty Menendez. So it was not, or it has no tendency in reason to establish what counsel is seeking to establish. And I ask that, above all, be excluded. We ask, in summary, that all the testimony of this witness be excluded. Unlike Alan Andersen, at least there was some limited areas related to specific acts of violence and other matters which were relevant and which could be presented to the jury. For this particular witness, we find nothing that is relevant or admissible. I can't even believe that they would try to do this. She has direct evidence of speaking with Kitty Menendez and Lyle Menendez when he was young, and him saying that he was being touched inappropriately by his father, and Kitty saying, just forget about it. This didn't happen, basically. Ms. Abramson responds, Your Honor, if I could just point a few things out, and then I assume the court is going to take some time. The court says, before you do, let me ask regarding the sexual abuse issue. Wasn't there a limiting instruction given in the first trial as to what the jury could do with that evidence? Ms. Towery says, in terms of the statement by Lyle Menendez to Diane Vandermolen? Yes. He wants him to get it in a different way? Wasn't there a limiting instruction? Oh, there a limiting instruction in the first trial about that evidence. Ms. Tari says, yes, the court received it as a fresh complaint, although the court did limit it to the fact that he made the statement and not for the truth of the matter asserted. Although at another time the court described it as an exception to the hearsay rule, and I know there's some disagreement among the reported cases as to exactly what fresh complaint means. Apparently, their court believes it is for a non-hearsay purpose, but in any event, the court says, well, that goes back to its relevance, what it proves. Ms. Towery says, what it proves, Your Honor, again, Mr. Khan has indicated that the prosecution will be attacking the truthfulness of the allegations of sexual molestation. Now, there was quite a bit of testimony by Erik Menendez relating to the sexual molestation of Lyle Menendez when he was a little boy. The court says, by Lyle Menendez. Ms. Towery says, I'm sorry? The court says, by Lyle Menendez? No, no, says Ms. Towery. There was also testimony by Erik Menendez relating to the sexual molestation of Lyle Menendez by his father. And I can, if the court wishes, I can point the court to those sections in the transcript tomorrow. I have them with me. The court says, you mean statements. I'm sorry to interrupt, but statements that Lyle Menendez related to Erik Menendez, that Erik related to the jury? Yes, says Ms. Towery. Court says about what was told to him. Exactly, says Towery. The court says these were received for the truth of the matter asserted without objection. Ms. Towery says, yes, I don't believe any of those statements were objected to. Ms. Abramson says, that's right. Ms. Towery says, so they were received for all purposes by the jury. And so that evidence is before the jury. And again, I think Erik, the court cuts her off and says, what is before the jury that Lyle Menendez said these things or that they actually happened? Ms. Towery says that Lyle Menendez said these things. The court says, okay, the fact that Lyle Menendez said them would be reflective of the state of mind of Erik Menendez at the time he heard the statements. Correct, says Ms. Towery. The court says, but what you're offering this for is in 82 and 83 or earlier than that. It was September. That was Ms. Abramson says, yeah, 76. The court says proof that was this was proof that Lyle Menendez had been molested by his father. So you're offering it for, Ms. Towery says, I would offer it for the truth because, in my opinion, the fresh complaint doctrine is an exception to the hearsay rule and reliable hearsay and should come in for the truth. And I would respectfully disagree with the court's apparent analysis. I don't know that the truth or that the issue was really discussing at the last trial, but the court says, but my guess is it probably was. Ms. Towery says, I'm sorry. Court says it probably was. I don't have a recollection of it. Ms. Towery says, I know the words fresh complaint were used. I didn't see a discussion as to what that means in the record, but that doesn't mean it's not true. It just means I didn't see it. Ms. Abramson says it wasn't discussed in the 402 to involving this particular witness. The court says there was certainly argument on the subject as to why it should be received or if it should be received. I don't have a recollection of specifics of that argument, but I'm sure there was. Ms. Abramson says it had to do because of the timing of that, Your Honor. That was before Lyle Menendez testified. Remember, we called the source witnesses first? Right, says the court. Ms. Abramson says, I think that at that time it was received in a limited way, only because he had not yet testified, and I think that's what the thinking was. But of course, my purpose in wanting it is because of what was told to Mrs. Menendez and how she reacted to it. Ms. Towery says, Your Honor, in addition to the court, by its comment seems to be taking the view that Erik Menendez's testimony about Lyle Menendez's statements that he was sexually molested somehow do not come in for their truth if objected to, and I believe they do, Your Honor, and that's our position. Erik Menendez testified to Lyle Menendez's claims of sexual molestation of him by his father. No one objected. The court says clearly hearsay evidence is fully admissible if it's not objected to. Exactly. That's my point, says Ms. Towery. The court says, and used for any purpose the jury wants. There's no doubt about that. Ms. Towery says, and what others might be considered hearsay evidence, there are other arguments we could have made that we could have made there. Let me restart that sentence. There are other arguments we could have made had there been an objection, but there wasn't. The prosecution says we're going to attack the sexual molestation claims. Presumably, that includes the sexual molestation of Lyle Menendez as well as Erik Menendez, whether or not the fresh complaint of Lyle Menendez in 76 to this witness, which occurred long before any possible motive to fabricate could have arisen. should be admissible. And again, I would submit not only to show that the subsequent statements that did come in objected to as for the truth are not fabricated, but also should come in a fresh complaint, which is an exception to the hearsay rule. Court says, well, let me cut that off at this point and just ask that counsel supply me with Xerox copies of the pages wherein that testimony was received during the examination of Erik Menendez without objection. Ms. Abramson says, okay. Court says, and if either side has any case law of the use of a fresh complaint, the limitations should be made of its use. You can submit that to the court first thing in the morning. Ms. Towery says, I think I can give that to the court tonight, Your Honor, because I pulled Justice Jefferson's comments about it. It went into the black hole of Mr. Gessler's file, so perhaps I would be able to do this. In any event, Mr. Gessler says, it's not a black hole, it's right here. We're going to find it right away, demonstrating that the black hole theory is fallacious. Ms. Towery says, Mr. Gessler takes offense at my use of descriptive terms. In any event, I didn't have a lot of time to look at that particular issue over the weekend, but I did take a look at Jefferson's discussion of the issue, and it's in my most recent update, which is in section 1.1, and the case is cited in there. And I admit to the court I have not read nor shepherdized these cases, so I'm relying on Justice Jefferson's rather than my own research. But the cases cited included are Mary Ann, and she gives a bunch of citations, case, which said that the fresh complaint doctrine was a new exception to the hearsay rule and should come in for the truth according to Justice Jefferson's description. So instead of, you know how they always say, this is hearsay, it's coming in for state of mind, but not for the truth of what's being said. This is saying that the hearsay rule, this doctrine is saying that a fresh complaint means that you bypass that it should be coming in for the truth. Then there's another case that she cites which describes the fresh complaint as non-hearsay to prove the touching element required for the violation alleged in that case. And the court cuts her off and says, so you're saying there are cases, to your understanding, that support a division based solely upon a fresh complaint and nothing else? I don't know that I can go that far. The court says, I thought that's what the case was saying. Meacham? I don't know. I haven't read the case. I'm telling you the case law. The court says, well, let's stop then. Ms. Towery says, the hearsay versus non-hearsay aspect of the issue. The court says, let's stop, and I'd ask that you read the cases and give me a report on what your understanding of the law is, and likewise to the prosecution. Ms. Towery says, okay. The court says, on that subject, and as I said, it was discussed before, and it could very well be that the discussion focused on the fact that Lyle Menendez had not testified. Certainly, there was a discussion regarding the offer of Donovan Goudreau's testimony, and his testimony was held back for that reason. Ms. Abramson says there was such a discussion before the witness testified, and hers was not held back. That's because it came up with Donovan Goudreau in the People's case. Court says yes. Ms. Abramson says it was held back from the People's case, whereas this was the defense's case. Court says, all right, we'll take a recess and we'll resume tomorrow at 8:30. I'd ask we all get here at 8:30 so we could hopefully get going before the jury gets here. Ms. Abramson says, we were very early this morning. The court says, let's all get here very early. Mr. Gessler says, may we provide the court tomorrow morning with those copies? The court says, yes, sir. Yes, sir. The transcripts, you mean? Mr. Gessler says, yes. Ms. Towery says, do you want to brief, Your Honor, on the fresh complaint issue? No. I don't want you to sit up all night writing briefs. Ms. Abramson says, she's fast, she's good, she's amazing. And now they adjourned. So that was a bunch of arguments for an hour and like 20 minutes. They just argued over, or maybe a little less, but they argue for over an hour about what abuse evidence should and shouldn't come in. Even though it all came in the first trial, why is this trial different? Why is everything so different in this trial? Why are we not letting things in? Why is every single little thing that the defense is doing getting objected to? It's insane. This trial compared to the last trial, it just seems totally different with these arguments. Although we streamed through the trial, but we didn't have all these sidebars. We only got like a few sidebars when we were watching. I don't think most of the sidebars were televised. And the things discussed outside the jury, which would have been these conversations that we're hearing. And there's a lot of really heated conversations where you can see they have completely polar opposite views of the evidence and everything in this case. And anytime the defense tries to make a move, the prosecution's like, no, you can't do that, even though you did it in the first trial. So it's all very confusing to me why this trial is so different. But that's where we're at. So on Tuesday, we will continue with part 72, which who's testifying? Oh, I don't have it up. Or no, this is 72. We will continue with 73. That's what I meant to say. And I can't remember who is testifying for 73, but I think Diane Vandermolen might be doing some testimony either in front of or not in front of the jury, possibly. I think Diane Vandermolen might be the next one. Anyways, that's all I have for you guys today. We will continue, like I said, Tuesday and keep on going through the defense's case. We're almost there. I think, you know what? Hold on. Okay, so apparently part 73, so your next episode is going to be a bigger argument between both sides about that fresh complaint doctrine and how to bring that in. And Erik's testimony about Lyle's abuse and things like that. So that's all going to be Tuesday. But I wanted to say also, that's why I came here. This is my spreadsheet of how all the episodes that we have left. So we're going to go through the penalty phase as well. So there's still a lot left. But as far as the trial portion, the criminal trial portion, the sentencing portion, I guess you would call it, we are almost complete with that, at least sort of. So the defense's case is going to go up to 92. Yeah, 92 parts, and then we're going to go, why did I lose it? Where is it at? Then we have a state's rebuttal and a little bit of the defense's third rebuttal, and then we'll have closings. Then we'll get into the penalty phase, which is not nearly as long as the rest of the trial. That's only 22 episodes. But where we're at right now, like I said, we have 92 parts of the defense's case. Then we'll get into rebuttal and surrebuttal and all that. But yeah, so thank you guys so much for watching. Wanted to give you guys an update on where we're at because I know it's a long trial and it helps to kind of see where we're at in the process. We have a lot more to go, clearly. So anyways, thank you guys for watching. Take care, and I will see you in the next one. Bye, guys. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. If you want more, subscribe and let me know what you think in the comments below. See you next time.